Who made a resolution for New Year? Well, I'm going to admit that I made a couple. The first one was to grow 6 inches taller and become the quarterback for the New York Giants. But I also decided I was going to see if I could learn to hablar español mejor. So that's one, and I'm going to do that. Well, whether you guys formally did this or not, you guys made a resolution to be better members of your community. And I'd like to say today's class is going to allow you to check off that you've achieved that New Year's resolution to become a better educated and a better member of your community and a better board member. Now, my name is Kelly Krittenberger. I'm the regional manager for Campbell's West Broward office. Been doing this for 23 years now, and I see lots of familiar faces. Thanks so much for being here. It's nice to see the new faces too. Campbell Property Management is happy to host today's event. This is a special area to us as we've been here for more than 40 years. And in that 40 years, among others, we've learned that being part of a community helps us serve the community. Today's class that we're hosting is one example of that. Another example of being part of the community and giving back is the generation of the Florida Association newsletter. That's a free e-newsletter that is sent out to you full of information for the industry, whether it's legislative updates, financial advice, or operational tidbits and landscaping information. Please make sure you get that. We've got Ashley somewhere here in the back, and you'll see Ashley, Andrew, or Diego to sign up to receive that free newsletter. Now, before we start, I do want to go through a couple things. Number one, out of respect to everybody here, do me a favor and put your phones on silent, okay? It's always funny when the phone's ringing and everybody's looking around and it's you. Anyway, take your calls, go out, but do what you need to do to not offend anybody else, because we'll have lots of information today. The other one is trying to avoid the questions that are specific to just you and your association. If you've got those, it's fine. Our presenters, Dan and Michael, will make time during the break and after their presentations to hear whatever those specific issues are, but keep them more generic to the condominiums or the law itself. I do want to introduce the people that have made this happen. I'm going to get started first of all, so if you would cast your eyes back here to Diego Hernandez. Diego and his teammate Ashley Deach from the marketing of Campbell Property Management. Thanks so much for making this happen. If anybody gets thirsty, it looks like we've got tons of water back there, so nobody's going to pass out due to thirst. Thanks so much for doing that. But also, Campbell's got lots of its property managers here, and I'm going to go my left to right. On the left is Jerry McGuinn. Despite his being a Buffalo Bills fan, he's a fantastic person we love talking to. Next, Wayne Sears, ex-basketball coach, among other things. All of our guys and ladies seem to have a good interest in sports and talk to Wayne about whether it's his JET Jets or not. Anyway, David Friedman. We'd love to have David. David knows everything. He should be nodding and shaking his head no to everything that Dan and Michael say, because he's like a Mensa. He's the man who knows it all. And his teammate is also David Friedman. And David has been with Campbell for more than 20 years. Did a fantastic job there in Tamarack and Margate. Brad Vogt. Brad is not only our regional controller, but he's also a property manager, and he's a get-it-done man who not only can break down your financials easily for you, but he can make things happen for you to get your loans or the collections taken care of. And last but certainly not least is our mighty Mike Donald. I'm surprised Donald didn't jump up on one of the tables and say, "My house, my house." Donna loves being part of this community. You can hear lots of her board members are here today supporting her. And she's like all those other managers, though, that love being with you guys and love being able to assist you and help you achieve your goals. Now, our agenda for today is we'll get started, and Dan Tiernan from Campbell Property Management will go through best practices focus mostly on those board meetings that you have when you get to shine and show how smart and organized you guys are. And then Michael Bender will give the board member certification class. So before, without further ado, I do want to introduce Dan Tiernan, the Chief Operating Officer from Campbell Property Management, graduate from Georgia Tech, Rental Home Engineer, and a terrific speaker. You will love hearing what Dan presents today.
One of the owners of Campbell. What we're going to talk about today is, first of all, the attorney, what he's going to talk about is what you can and can't do, what you should and shouldn't do from a legal perspective. What I'm going to talk about is more what you should do to be more efficient and effective. And I'm going to focus on one specific area, and that's board meetings. And the reason we're going to focus on board meetings is that's really kind of the first perception you give to your community. If you can run a really effective board meeting, get things clearly done, and manage it effectively, it instills confidence in your members and your owners. And if you have a really disorganized, ineffective board meeting, it tends to reflect poorly on the board members. So that's what we're going to focus on, that one specific area. Now, quick show of hands just to get a sense of people's experience levels here. How many people are, new to the board or, less than a year? Raise your hand. All right, how many people between 1 and 5 years? All right, how about like 6 to 10? All right, a lot of them too. 11 to 15. We're starting to pare down now. How many grades up? 11 to 15. All right, anybody over 20? Over 20 years experience. Wow. Put them up again, let me see. 20 years experience. 1, 2, 3. Wow. Okay. 3. So, for those people, whoever said they have over 20 years, please keep your hand raised. I hope. All right, so Ashley, Diego, please give each of these people a gavel. They're my assistants. Okay? So, I think we might be out. We might not have enough gavels. But, so if you ever at the end of the point you have special notice, you can just bang on there and add a comment or ask a question, okay? You've got 60 years experience among the three of you. We want to hear what you have to say. All right, so first of all, the most important thing is to understand what makes for a good board meeting. And I think the easiest way to understand that is to figure out what's a bad board meeting and what's maybe the opposite. So any ideas, what do people think makes for a bad board meeting? What's a bad board meeting like? Too many people are talking. What else? The residents interrupt all the time.
They don't show up.
What? They don't show up? Okay. All right. Well, I guess when I hear all these things, it normally comes down to 3 things, which is that it takes too long, nothing gets done, and everybody leaves unhappy. That's kind of the worst case scenario of a bad board meeting. So what we're going to focus on is the opposite of that, which is that it takes a reasonable amount of time, you get a lot of things accomplished, everything you intended to get accomplished, and everybody leaves happy. So that's kind of the dreamy scenario, but everybody leaves reasonably satisfied. So just another quick poll here. How many people would say that your standard board meeting, not one where there's a special assessment or a material change vote or anything like that, but just your standard board meeting would typically take an hour or less? How many people would say that would be the case? All right, that's 20%. How many people would say it takes between an hour and 2 hours normally? Almost as many between an hour and 2. How about over 2 hours is a normal board meeting? All right, we got a few there. Okay, so our goal, we would tell you that you really ought to shoot for being able to have a board meeting in an hour or less. That's a reasonable goal. And there's some exceptions to that. Again, if you're having a special meeting where there's a major project being considered, a special assessment, something more complicated. But a standard board meeting shouldn't take more than an hour. And the other exception would be to that is like, does anybody in here have a board of more than 15 people or more? All right, so those can just, those can fundamentally take a little bit longer. We want to get their points in. All right, so that's our goal, is to talk about how we can have a board meeting where get it done in less than an hour, get a lot of things accomplished, and everybody leaves happy. So we're going to do this with based on 9 steps. And I'd love to tell you that I was smart enough to come up with all these steps on my own, but I didn't. I cheated. So Campbell has 100. I think now it's 135 licensed CAMs. We manage 400 properties with over 100,000 units. And when I add up all the collective years of experience of those managers, it's well over 1,000 years. So what we do is we get our managers together 4 times a year. We have them come together and we talk to them, we educate them at the same time they educate us. And I ask them questions like, hey, what's the lead to an effective board meeting? And they sit at round tables like we're at, and they all write down notes and they come up and they present to us. And then I furiously videotape and write this stuff down. And we come up with this 9 steps to an effective board meeting. And then what we do with it is we put it on our blog. Our blog is, who knows what our blog is? What's it called? Florida Association News, right? So it's free, and it's just educational stuff. And then one of the things it has in there, so if you don't want to write a bunch of notes today, you can just look it up later on the blog, 9 steps to an effective board meeting, and it's on there. And there's lots of other information on there as well. So make sure you check that out. And it's at readfan.org. Ashley and Diego back there have all the details on it. So the first step, like anything, is to just make sure you're prepared for a board meeting. And that means, having a really solid agenda that only has items on it that you're ready to act on. So you don't, if someone comes up with an idea and says, oh, we should talk about replacing the mailboxes at the next board meeting. Yeah, let's put that on the agenda. No, that's not, you don't put it on the agenda to discover it and pick ideas around. You would put it on the agenda when you're ready to make a decision on what mailboxes you're going to put in based on the bids that you have, and you seem to have gotten a consensus on it. So if something is taking a long time, if you think it might take a long time, it probably shouldn't be on the agenda. You should be having individualized meetings or phone conversations offline and try to build some consensus, which is all fine and good, because you don't want to do it until you're really ready to act. I'd say that's one of the biggest mistakes I see people make. They put things on there that they really aren't ready to act on. And the other key thing would be to make sure that you have an effective board package, right? So the board package should be delivered, at least like 3 days before your meeting, and it should have any bids that you need to consider, that kind of thing in there, documents you need to review that are related to the action items. So if that's not happening, then make sure it is, because again, you want to have already reviewed the material before. You don't want to be discovering things while you're in that meeting. So again, just being prepared is incredibly important. The next step, again, kind of a preparation thing, is making sure that you've got the right setup and equipment, right? So if you've got a large audience, maybe you don't always have a large audience. You don't need a microphone, but if you feel like you might have need one, get a microphone. And if you, how many people have snowbirds that might sometimes call into a board meeting? Do you guys have that? So what's the most popular method to try to deal with that? People do this. They get their cell phone out, they put it on speaker, they set it on there. And that person can't hear, you can't hear that person. It's just not a good situation. So, if you need to invest in a little speakerphone, do it. And in fact, on our Florida Association News blog, I show you can buy one that doesn't require a power source, and it ties to your phone, and it's $100 on Amazon, and it works pretty well. And likewise, if you don't have a speaker system, it used to be that by these really expensive speaker systems, audio-visual systems. Now I tell people, one of the things you can, again, you think I'm an investor in Amazon or not, but you go to Amazon, you can buy a karaoke box for $100, and it works as a really good speaker system. I know, because I have a teenage son, and I've had to borrow this karaoke box. It's carried around with you board meetings. I just walk in with it, pop it up, and it works great. And you can do karaoke after. Again, just making sure that you've got the right equipment. One final thing is just literally about how you sit. So most board meetings that I've seen, you see a long table up front like that, and then the audience is sitting like that. Who can tell me what actually is the ideal way that you should set a table up? A horseshoe. Yeah, horseshoe is absolutely the ideal way. Why is the short horseshoe the ideal way? So everybody can see each other, right? Because this is a board meeting, so who should the board members be talking to? The other board members, right? So just remember the purpose of this meeting. If the owners are there to observe and listen, and they have a limited right to speak, which we're going to talk about a little bit later, but make sure that you don't lose sight of that. Because a lot of times when you do the straight line like that, it gives people the false perception that you're talking to them, and you're not. You're really talking amongst each other. So an alternative to that is make it a V, make it a U. You don't have to buy a horseshoe table. So, but making it so that you're looking at each other and seeing each other. And then one other important item, whenever you need to bring order, what's a real simple thing to do instead of saying, order, order, what's another option? Gavels are awesome. And they're cheap, and Campbell has lots of them. If you don't have one, just ask us, and and Ashley can get you one. Much better than screaming. So, and one other thing is we're seeing more and more places are trying to accommodate owners, that might even be out of town, and it's gotten much simpler now with things like video streaming like FaceTime, and so more and more people are doing that. And again, it's not a super complicated thing to be able to do. So if that's something you want to try at some point, you haven't done it before, just talk to your manager. We'll get with Kelly and us, and we'll kind of help you figure out how to do that. Because again, more and more people are wanting to do things like that. The next thing is really just as you're setting your agenda up, whoever's preparing it, we would normally suggest that the ideal scenario is the president and the manager together are working on it with input from the board. But to try to look through it and ask yourself, can we get all this stuff done in an hour? And think through, all right, we're going to have a conversation about, putting bird feeders in an area, or putting some benches out front. These are topics last night on our board meeting I was at last night that should have been on the agenda because I could tell when I got there they spent too much time talking about it. They hadn't really thought it through. So, if you know that it's going to be 10 minutes to talk about this one item, something's wrong. And you have to ask yourself, maybe we should be putting it off to the side and doing some more research on it, trying to get a better consensus so that we don't spend too much time on it. There's also a lot of times, particularly with the boards that have a lot of people, with 15 people or so, there's 3 words you can say. I mean, if you've been in a situation where the people start saying the same stuff over and over again, and it's kind of repetitive, and you can kind of tell, hey, we're ready to vote. I mean, we really need to keep talking. It's already kind of decided. It's an overwhelming 3 words you can say to just end the discussion, which are what?
Call for question.
Call the question, right? So call the question. That's a great way to do it. Another interesting thing is, can you make a motion and then vote against it?
Sure.
Absolutely you can. A lot of people don't think about this. If somebody's talking about something and you want to get it over with because you know one, you say, I'd like to make a motion to spend $1 million to knock the clubhouse down. I want to make it right now. Yeah, second, right? And then everybody votes against it except the one person that wanted it. And it's done. You don't have to keep talking about it. So it is kind of odd. I rarely see people do it, but particularly with bigger boards, calling a question and making the motions and then voting them just to get it done sometimes makes sense. The next key point is declaring the ground rules. This is a real important one. So a lot of times what happens is, the same people tend to show up to board meetings all the time, right? They kind of know what the rules are. But occasionally, new people come. And so I always suggest to boards that they tell everybody at the beginning of the meeting, they get in the habit of doing it. Almost like, I know we have some boards that we work with that they'll say the Pledge of Allegiance every time. It's something they always do right before the meeting starts. So you get in the habit of doing that. And the other habit would be to say, just to remind everybody, this is a board meeting. And the board meeting is meant for the board members to speak. You have a right to listen and observe, and you can ask questions on a limited basis. And here's the rules of how you can ask questions. And do that at the beginning of every meeting. That way, you don't find yourself in a situation where someone new's come in and they think this is a town hall meeting, they just start interrupting all the time and you have to admonish them. So just get yourself in a habit of doing it, or even putting it at the bottom of the agenda or the back of the agenda, putting the rules about what the rules are related to being able to speak. we have a really simple policy on that you can take. We've already written it all out, and we can share it with you, and you can edit it as you need, and it's pretty straightforward. But it really kind of helps calm things down. The next one is a real kind of obvious one. It's just making sure that you stay on topic and stay on time, and that you don't add something. You don't just add something to the agenda that's not on there. Why is it important to not add something to the agenda or to talk about something that's not on the agenda? Why? Not prepared, not enough time, exactly. And also, it's literally not legal. I mean, that's the whole point of having the agenda, is that you're telling people, look, these are the topics we're going to talk about. That way, if the owners are interested, they can come and show up and listen. So you shouldn't be talking about things that aren't on the agenda. Okay, then the next item is, we talked about this a little bit before, is just making sure that you let members speak. So this is, again, kind of just setting the rules for how you want to have that happen, when they're recognized, at what point. So one of the things I think a lot of people, do any of you wait to let all the owner questions come to the very end? Does anybody do that? Okay, so it's actually what you can do. If say you have a big project going on, you have a legal right to go through the whole thing, have a complete discussion with the board, vote on it, make your decision, and then not let owners wait, and then wait till the very end, and then let the owners speak. Okay, that's actually okay. It's just really stupid. Okay, you shouldn't do it. I mean, it's legal that you can do it, but you shouldn't do it. So if you've got something that's conflict that's going to happen, you let the board speak first, and then you should let the owners speak and ask questions about it, and then you should vote. Again, you don't have to do it that way, but you really ought to do it that way, just from the standpoint of respecting the owners. Yes?
I keep mentioning that it's legal. What gives you that legal authority?
Just, I'll let Michael can get into all of that. So, but it's, I probably shouldn't say it's legal, but it's a good way to do it. Okay. All right. So, and the next one is Robert's Rules. Does anyone in here consider themselves like an expert in Robert's Rules? No? Okay, good. I always tell people, if you're like a black belt in Robert's Rules, don't use it at your meeting, because you're just going to confuse everybody and beat them all up. It'll be a hot mess. Okay, so Robert's Rules is a very reasonable guideline, but a whole bunch of what it has conflicts with what you're supposed to do, different pieces of it. So just make sure you understand the real basics about, declaring a quorum, adjourning meetings, getting motions, getting seconds, how you write it down, just calling a question, tabling things. There's really about 10 or 12 things you need to know, and then all the rest of it, a lot of it literally might be irrelevant, and it just confuses a lot of people, and you don't need to make it that complicated. And then the next one is, I think, a really good one. Does anyone know who I got this from? Don't criticize, condemn, or complain.
Yes.
It's a Dale Carnegie quote. So how to win friends and influence people. So, this is something that is, I think, one of the hardest things that happens. I mean, have any of you guys ever been in a situation where you've gone in, there's something controversial happening, some people are upset, they're going to show up and they're going to say something really nasty? Have you ever, that's going to happen, right? So what's the, a way to handle that? Have you ever sat down ahead of time and thought through, how am I going to respond to this? Because what you don't want to do is you don't want to come back at them or scream or hit at them or throw your gavel at them. You want to think through what you're going to say. So you literally can just come up with something before you have it happen, which says, I know what I'm going to say is, thank you for your comments, although I disagree with what you said. I believe it would be untrue and potentially even slanderous. We're going to move on and move on to the next point and be done with it. Don't get into debate with it. So come up with something that's like less than 20 seconds that's your standard, and then you can just use that. It'll make you feel like, oh, I got that out of my system, and done, and you can move on. The next point is meeting minutes. So I just actually wrote a blog post about this the other day. A lot of new board members will run to be on the board because they'll say, this is the most popular word I hear from new boards. We'll see if you guys can say, what's the word? What's a key word that you can think of when someone thinks that this is what they want more of? Transparency, that's it. Transparency is a huge word you hear. People will always say, I want the board to be more transparent. And then some new board members will come in and they'll think, well, okay, part of the way we'll be transparent is we'll put everything in the minutes. All right? And you don't want to do that, okay? So you can have Michael explain that later on, but it opens you up to all kinds of legal liabilities. It also just makes your job way harder. All that really needs to be in the minutes, again, I just wrote a blog post on this last week, are, fundamentally just the decisions that are made and what the votes were. That's really what needs to be in there. And, have any of you ever had someone say something, I want the minutes to reflect, blah, blah, blah? That's like exactly what you don't want in the minutes, okay? So it really is supposed to be, you don't want all the comments, it just makes it way too hard, and it also opens you up to all kinds of legal liabilities. So, again, that's the, those are the key 9 steps to an effective board meeting. Again, Florida Association News, you can find the blog post that kind of summarizes it, and a lot of other things that I talked about today. So I hope you get a chance to check that out. And there's also on our website, is it for the people that are newer to the board, or even if you've been on board for a while, we've written out a board member primer. It's kind of a basic guide for board members trying to understand what their roles are and some key tips on things that might come up in it. And we recommend about 12 different blog posts they read that are kind of some of the common challenges. So that's it. So with that, I'm going to turn it over now to Michael Bender. Michael is going to, oh wait, I'm going to turn it over to Kelly. And Kelly's all right. Thank you all.
Dan always does a terrific job with that subject, and that's the key. Again, that's where it gives you an opportunity to show the unit owners how well informed and organized that you are. So do what Dan has said and go get the information. You're not going to absorb it all, but get it so you've got it in the paper form so that you can make sure that you're always looking as professional as you are. Okay, so our featured speaker today is Michael Bender. He's a partner with Kaye Bender Rembaum. He's been an attorney for 26 years, and for the last 20 plus, he's been focused on the community association. And Michael is the chairman of the Florida Legislative Alliance of CAI. He hosts a radio show, and he and his firm do lots and lots of educational classes like today. Some of you may have seen him, and we're lucky to have him back because he's back by popular demand. So I'm going to ask Michael Bender to come forward. Please give him a round of applause.
Good morning. Good morning. How is everybody? I like they gave me a low podium, so very easily to be seen. Happy New Year. It's good to be back doing these programs with Campbell and Dan and Kelly, and I want to thank them again for putting this together, and Ashley, of course, for all the hard work. It's a pleasure to be here. Great crowd. What we're going to do for the next couple of hours is we're going to be talking about the condominium board member education program, which is the certification requirement for condominium board members. Before I do that, I want to make sure everybody has their folder. Everybody picked up a folder. Christine and Barbara, can you walk around with 2 folders? Raise a hand if you didn't get a KBR folder. You guys skipped the other table. It's just this one group. Not all of them, though. Not all of them. Right there. There's a couple right there, too. Okay. Okay? Inside the folder, this is your materials here. Okay? By the way, you all can hear me fine, right? Okay, good. These are the materials we're going to be following. Okay, I will tell you now. This class, especially because I want to give opportunity for Q&A, can last a lot longer than we have. Okay, so it is now, Dan did an excellent job of keeping on schedule, and I'm going to try to do the same. We're going to get started by the time I get through the intro. We'll get started about 10 after 10. We have about 2 hours and 15 minutes to go through, what I would consider 3 hours worth of information. There is a scheduled break. I prefer, unless there's any objection, that we don't take an official break, with everybody having to get up and come back, that we would lose a lot of time. By all means, if you need to get up, get something to eat, use the restroom, please do. I'm going to just continue through with the program. Is that agreeable? Yes. Great. Thank you. Okay? So, as I said, this is in the materials. I want to make sure that you follow along with this. There are certain sections I will simply point out, I will not discuss, but I think we've done a very nice job of explaining them in the materials, and then in this way we can focus more on some of what I consider to be the more substantive sections, meatier sections, and have some Q&A time as well. There is also a survey in your folders. You have a survey from Campbell and you have a survey from Kaye Bender Rembaum. We do ask that you fill out both and give Ashley the Campbell survey, give Christine and Barbara on the KBR table the KBR surveys as you're wrapping up. You get your cell phones already are off, so that's good. The one last item I do want to mention, Kelly mentioned we do a lot of education. I see a lot of familiar faces. You guys have seen us in different programs. Inside the folder, there is this flyer called Ask the Attorneys. This is a town hall program that our law firm has done now for 12 years. Today, we're doing a board member certification. It's material that is specific. It is the ABCs. It's the foundation. It's not in depth. We do classes. We do an hour class on covenant enforcement. We do an hour class on fair housing and local support animals. An hour class on sale, lease, and TULA rights. An hour class on elections. Those are substantive and spend an entire time. Today, we don't obviously have an hour, so we're going to touch upon these. The Ask the Attorney Town Hall, you, the attendees, set the agenda. People come, and they bring their questions or their topics, and we discuss, basically it's myself and Robert Kaye for 2.5 hours. It's that way, it's give and take. Okay? The reason I want to mention, you see in here, and I'm not sure where people, I assume a lot of you live more locally here, but you're probably from around the area. There is 2 in February, one in Bonaventure, one at the Art Circle in Fort Lauderdale. But tonight, if you have time and you're available, tonight there's one at the Village Civic Center at 6800 Sunset Strip. That is tonight at 6:30 at the Village Civic Center, 6800 Sunset Strip. Starting at 6:30, we'll be serving food. So you can have dinner there, or at least a light dinner, pre-dinner. And so I do it, if anyone's available and they want to come to get more education, it is certainly free to attend. And I know if you don't have an opportunity to, if you didn't get an email blast or RSVP, it's okay, show up, sign in. Okay. Everybody here is condominium, correct? Because I am not going to be addressing HOA or cooperative today. Good. All right, then, with that, any questions about anything administrative? Good? All right, well, I may go back and forth with these because it helps me read. All right, great. So what I'm going to do is I'm going to start on the first page. And the first topic that we're going to talk about is condominium operations. And this is going to be the largest topic that we go through. It's got the most information. And what I'd like to do, with your permission, I'd like to go through the section. And there are 7 sections in the material. The state says discuss 4 of them to qualify for certification. My intent is to discuss at least 4 and maybe 5 if we have the time, and simply point out the other 2, and so you're aware of them. But what I'd like to do then is I'd like to go through the entire operations section, If you have questions on some of the subject matter, I'd like you to write it down. You have a pad and a pen that we provided. And I will take questions in between each section on the materials I just went over. And this way, I think that'll allow us, I may answer your question before you get to have to ask it. But if not, I will take those questions and then move on to the next section, hopefully also leaving us some time at the end for more Q&A. Okay? Great. All right, so I want to start very quickly with a couple, again, reminding you guys, this is the ABCs of management. How many of you have served on your board for a year or less? Okay? How many of you have served on your board for 1 to 5 years? 5 to 10? More than 10? People, I want you guys watching those hands because I don't know what's up with them. Okay, anybody 10 or more, hands up because I want Kelly and Donna to watch you guys. Make sure you're okay. Yeah, okay. Definitely watch her. Okay. So those of you who have been on your board for a long period of time, and even those of you who have been on your board for a short period of time, but you presumably have attended some board meetings, or maybe even in your business lives, you've been on boards. What you're doing is you have volunteered to help run a business. That is what your associations are. They are your friends and your neighbors, hopefully all, but sometimes there's a couple maybe not. But they're, you know, but the bottom line is these associations are corporations and they are businesses. And so you are running a business. You have volunteered to do so, and in that regard, you have what is called a fiduciary duty. Okay? So when you move into a community, you move into your condominium, you have, what it is you basically, the declaration of condominium, the article, bylaws, and the rules, those are contractual documents. You don't actually sign off on them. You sign off on your title work, but those documents, you now have a contractual obligation with the association. So as an owner, your responsibility is primarily twofold. One, pay your assessments timely, and two, follow all the rules, regulations, restrictions, and just be a good friend and a good neighbor. When you choose to step up and volunteer on that board, you now have the fiduciary duty, an enhanced duty, to not only pay your assessments and follow the rules and regulations, but also to undertake whatever actions are necessary to ensure the smooth operation of that community and do what's in the best interest of the community as a whole. Hopefully, that jives with your own personal interests. Because as an owner, all you have to care about is your self-interest. But if you choose to volunteer and step onto that board, you really need to turn that hat sideways, put your board member hat on, and that's how you make your decision. Okay? So these governing documents that you are responsible to uniformly enforce, your declaration of condominium, your articles of incorporation, your bylaws, rules and regulations, in that order. Your declaration of condominium, that's basically your constitution. It governs how you live in your community. Your articles of incorporation and your bylaws, they create the corporate entity and primarily should govern how the corporation is run. Quorum requirements, size of the board, the election process, meeting requirements, notice requirements, things of that nature. Your rules and regulation, they generally supplement those other three documents and primarily your declaration. The rules and regulations are in place to clarify. So if the declaration says that the board has the authority to maintain the common element, the board has the authority to create rules, and we'll get into that a little bit later. The board then may be adopting rules that govern how the community pool is run. Okay? So those are the four documents, and we're going to get a little bit deeper into how the enforcement works in another section. But I want you to be aware of that. Because when the condominium association is responsible for the operation of the affairs, the board is who governs that association. And you are elected or appointed to do that, and you're expected to do so in a way that is responsible and reasonable. Okay? Business judgment rule, is that a term you've heard? Okay? Business judgment rule is what you are given or allowed when you govern these communities. And what that means is when you have issues that come up and present themselves, You have your business advisors, your Campbell management team. They're your business advisors. Maybe if it's an insurance question, you have an insurance agent. An accounting question, your financial question, your accountant. Legal question, your lawyers. Okay? Our role is to offer you, as the lawyer, our role is to offer you guidance. You come to us and say, here are the facts, here's the issues. We say, okay, let's review your documents, let's review the law, apply the facts, and then here, board, are your options, assuming there are multiple options. And here's the cost-benefit risk assessment to those. You now, as a board, have a fiduciary duty to make a fully informed, you now are in a position to make a fully informed business decision based on guidance from your corporate experts, if you will. Making those decisions is what the business judgment rule is. And the reason why it's relevant is that you don't, if you make a business judgment that ultimately isn't the best, that doesn't mean that you are now in trouble. It doesn't mean that, that what you've done is going to be overturned in a court of law. Because a judge will not, a judge should not, a judge should not exchange their judgment for yours. That's what the business judgment rule is. Okay? So when you are managing, maintaining the property, that's how it works. Get informed, okay, fully informed on the issue at hand so that when you sit down at that table, your board meeting table, you're able to make fully informed business decisions. Does that make sense? Yes. Okay? When we talk, I want to, okay, so, and again, like I said, I'm not going to read through these materials. The materials are there for you to read through when you have some time. I'm going to highlight some, I'm going to expand on some, but it is a book, obviously, for you to take back, and then if there are questions that arise, come to some of our programs. If we are working with you currently, you can certainly ask. You certainly can follow up with your management team. But as Dan probably pointed out, don't ask your managers to give you legal guidance. Okay, it's not fair to burden them with that. They're certainly well educated, and the guidance that Dan gave you on meetings is invaluable. But the gentleman asked the question, what's the legal basis? And it was great. Dan gave a perfect answer. Yeah, it's like, hey, that's for the attorney. I'm not an attorney, but here's what I understand from my X+ years of experience. You should follow up with your counsel if you need a legal opinion. Okay? So so that's a lot of general overview because I think it's very important if you're, as again, in the giving the foundation, the ABCs of being a board member, that's where it starts. It's understanding your role and the role of your team, which is your management, which is your attorney, which is your accountant, which is your insurance expert, and any other vendors who you retain to work for and with you. Okay? I think if you take nothing more from this, I think that's an excellent information to take away. Getting into some more specifics now. Okay? And this is about just talking about material managing and maintaining and limitation on improvements. I'm going to highlight some of the issues that come up for board members that we get asked the most questions on. And one of those is the material alteration question. Okay? The 718.113.2a, no material alteration of the common elements or association property may be undertaken except in the manner provided in the declaration of condominium as originally recorded or as it's amended. Okay? If they're silent, which is rare, but it happens. In fact, I just had one the other this week. If it's silent, then if you want a material alteration, the board needs to get the 75% of the owners to approve, support that alteration. Okay? The issue here is, A, is what you're doing considered an alteration or improvement that would require a vote of the membership? That's the threshold question. And that obviously is fact specific. But not every alteration will be considered, will require a vote, even if it is an alteration. And I'll give you an example which set the precedent. There was a building that was on the water, and it was the land was eroding and the building was sliding into the water. The board, on its own, approved an $800,000 contract to build a seawall. And the owner sued, saying, wait a minute, you need membership approval to do that. Now, there was no seawall before. Had there been a seawall and they were simply repairing it, I think we all can clearly see there's necessary maintenance versus material alteration or alteration improvement. Necessary maintenance, there's no question you have the right, not only the right, the obligation to do. Alteration improvement, then depending on your documents, you may need to go to the membership. Okay? So, this particular example, there was no seawall. So, is the creation and installing of a seawall an alteration or improvement? Okay? Absolutely. But what the court said in this instance was, while that is an alteration or improvement, it's also necessary. Because if you don't do it, that building slides into the water, those owners who are screaming they need a vote are going to be really pissed. Now, and I'm paraphrasing, that wasn't quite the opinion of the judge, but that's essentially what we're talking about here. Imagine going to the owners and saying, guys, we need to build a seawall to save the building, and we need a majority of you to approve it, and we can't get a majority. So I guess we don't approve it, the building slides in. So what the court basically established, and this goes back decades, and it was, you know, there are times where judges nail it and really help us out as associations, and I live in one too, so this is something I deal with on a personal level. When the requirement is necessary, notwithstanding the fact that you have an obligation in your documents to get a vote of the membership, to do an alteration, you as a board will have the authority to undertake that and even to levy a special assessment to pay for it if that's the way it has to be done. And it makes sense. Remember, we started this whole program with what your obligations and your duties are as board members. And maintain the property is way up there. So if you need to maintain the property. Now, whether the issue is one you need a vote or not is absolutely a question that should be presented to your attorney if you are in any way unclear. It's not something your manager can absolutely give you their thoughts, but it's a legal issue that should come to your legal counsel, someone who you know, trust, experience in this area, and can give you guidance, and in fact, a written opinion that you can rely upon when you make your business judgment. Okay? So, if it's necessary maintenance, even if it appears to be an alteration of some kind, you have the right to do it and the right to special assess. Keep in mind, if instead of a special assessment, you want to borrow funds, that may require a vote. Okay? You have the right to do the project, you have the right to levy and impose levy that special assessment. But if instead you want to borrow and then either pay it back through your budget line item or even do a special assessment to pay back the loan, the borrowing of funds may require a vote of the membership if your governing documents require it. Chapter 617 of your Florida statute, which is your Not-for-Profit Corporation Act, which applies to all, as long as it doesn't conflict with 718, says that you have the right to borrow and pledge assets unless your articles bylaws say you don't. So it's important to review those documents and get an opinion from counsel. By the way, if you're borrowing funds, the bank is going to want an opinion from counsel confirming you have the right to do it. So just keep that in mind if you're ever doing these projects. And to give you one last example on this, you have a roof that has to be replaced. Necessary maintenance? Absolutely. It's a shingle roof, and you need to replace it. You're going to replace it with barrel tile. Necessary maintenance? Right. The roof is necessary maintenance, but the change from shingle to tile, now you're looking at an alteration or improvement, and that may require a vote. So keep in mind, even when it appears, hey, I'm just replacing our roof, you need to know if you're doing same for same, you should be okay. I will also let you know that the division, which is where these complaints go to, takes a very conservative approach. If you're going to change a paint color, they believe that's an alteration that may require a vote. Okay? So be aware and reach out and get guidance. Okay? Okay. Right of access to units on page 2. Okay? This is another situation that comes up quite often. Unfortunately, you have situations where units are abandoned or unit owners are living there and not properly maintaining. The association is granted by statute, 718.111 subsection 5, a right of access to an individual unit during reasonable hours and for the purposes that are set forth. Maintenance, repair, or replacement of the common element or any portion of the unit that the association is responsible to maintain, or to make emergency repairs necessary to prevent damage to the common elements of the unit or adjoining units. Okay? As of July 1st, 2014, which I can't believe that's now almost 6 years ago, the association may enter an abandoned unit to inspect the unit and the adjoining common elements and make necessary repairs. Unit is abandoned, the definition of abandonment is in the documents there, and you also can charge that owner of the abandoned unit on their ledger with the cost of repairs and treat it as an assessment. Recognizing, of course, if the owner's abandoned the unit, it's, the likelihood you get that money back isn't guaranteed. But the point here is you have the right, and in my opinion, the obligation to go and address these things. If there is an abandoned unit and there's no AC on in that unit, and there's moisture buildup, which is going to lead to mold growth, and that mold growth is going to go into the common element, and then it's going to spread into other areas, that is going to be a big problem for the association. So be proactive. Be proactive. Catch it early on, and then the out-of-pocket cost to the association will be far less. Whether it's a cost of doing business or whether you can get it reimbursed is issue 2. Issue 1 is address the problem as early as possible. Okay? Then work with your counsel to figure out, hey, how can we get this money back in the most efficient and least expensive way possible? Make sense? Okay? This has recently come up twice this week, so I'm just going to point out. If your declaration or your rules provides that you can require unit owners to provide access keys, then they must. If the board does that, you have to have procedures in place which will safeguard the keys, as well as have good procedures for accessing the unit. Okay? So, if you have in your governing documents either your declaration or your rules, typically one of those, that your owner must provide a key. Okay? They must. And if they're not providing a key and you should be uniformly enforcing it, that is an actionable offense. That is something where I've gone to arbitration, and the arbitrators have ruled in favor of the association. This individual was required to turn a key over and reimburse them like $2,000 or $3,000. Ridiculous. Oh, that's few and far between. I have one now where there's thankfully an attorney on the other side, and hopefully just going to make a phone call to this attorney and say to him, what are you doing? This is silly, let's resolve this. But be aware that if you require access keys, you can, and you need to make sure they're safeguarded, and you have a procedure in place that safeguards them, and the procedure for accessing the units. And I want to just tell you this, my opinion, and by the way, this is not legal opinion, I'm giving you information. Okay? Remember, this is informational purposes, not legal advice. But my information on this is the following. If you are going to be accessing units, and you've confirmed that you have the right to do so, okay, I recommend you go in with more than one person, and the moment you walk to that door, have a video camera, have your phone out, and you videotape. And by the way, if you're using a locksmith, I would request maybe local police be there, so that they can see that what you're doing, that you're not breaking in. But you videotape. Here we are, here's the unit, we are going to access the unit, here we go. We walk in the unit, here's the condition, here's exactly how everything looks as we speak. Notice there's nothing on the counter, so when the owner comes back later and says they had a diamond ring or $1,000 in cash on the counter, we can say you didn't. You know, that Ming vase of theirs is totally intact, we didn't touch it. Okay, boom, 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 boom. Okay, and here's exactly what we're doing, here's where we're going, boom, boom, all right, and now we are leaving. So at least you have, that is just gives you a level of protection in the event someone makes an allegation or a claim otherwise. And by the way, you then videotape, the videotape ends with you showing you've secured the unit. Make sense? Okay, good. All right. Preparing annual budgets and financial reports is something that well, the budget we'll talk about in a moment. The financial reports is a section I've written here, which I'm not going to get into. It's rather self-explanatory. You're required to obtain and maintain adequate insurance. Let's put it this way. You all have an insurance agent that works with you. There are some, there are very knowledgeable insurance agents and companies in the field of communities, condominium associations, and I presume you're working with one of them. And if you don't already, I encourage you to get with them at least once, if not twice a year, to go over what policies you have in place, what coverages you have in place, what your deductibles are, and to just ask the question, hey, are there riders or other policies that we don't have that we might want to consider. Okay? And by the way, if you're, those of you working with your Campbell Management, these things are likely covered because your management team is right on top of that. But as board members, you should also be aware. Okay? The association is responsible to ensure what is set forth on the top of page 3, and the exclusions are set forth just below that. Okay? What I want to briefly talk about is, with regard, this is another big topic. Who's responsible for? Okay? Who's responsible for blank? Okay? And whether, who's responsible? There's a roof leak, there's a pipe leak, whatever it is. These are going to often be fact specific. So I will generally let you know this. You have, if you can picture my hands being like bubbles, maintenance, insurance. That's your first question. Is the issue at hand, is it a dripping pipe? Maintenance. Is it a bursted hot water heater? Insurance. What happened that caused the problem or the damage? That's what we look at first, so we can establish, is this an insurable event or not? Is it something that, because if it's an insurable event, and again I'm speaking in general terms guys, okay? But if it's an insurable event, generally the association will have the responsibility to address the damage, so long as the damage is to the condominium building, the unit. Obviously you have the obligation to address the common element. Association addresses the common element. But whether you're responsible to address the unit will depend on if it's insurable or maintenance. If it's insurable, let's say there's a water damage to an interior wall of a unit. Okay? Now, again, let's also presume your governing documents define the unit to include that interior wall. There's no question this interior wall is part of the unit, not the common element. We look to see what caused the damage. Was it an insurable event? If it's an insurable event, we then look to see, okay, so now we are going to cover all portions of the condominium property as originally installed or replacement of like kind and quality. So, if this interior wall is part of the original construction, and it was a hot water heater that burst, and water dripped down and damaged this interior wall, that is going to be covered through the association's insurance. Okay? Okay. If it's not an insurable event, then, by statute, we now look to see it's under maintenance. And we now need to go to your governing documents, which are not all the same. Your governing documents and ascertain, okay, if it's not an insurable event, who's responsible for paying for this? Who's got the maintenance obligation? And if it's an interior wall, part of the unit, more often than not, the maintenance of that would be what fall to the owner, and that's why, as owners, it's imperative that you have, I recommend, that you have your own unit owner HO6 coverage. Okay? So the issue when it comes to its necessary maintenance versus insurance is that's what we look at initially. And again, like I had said earlier, if it's an association obligation, the association will take care of it. If the cause of the damage is due to the provable negligence or willful act of an individual, then the statute does allow you to then go back after that individual to reimburse the association for your costs, including the deductible. The deductible is generally a common expense, by the way, but if it's something that you can prove that it was the reason that this insurable event occurred was due to the negligence or intentional act of this owner or this owner's occupants, then you can go back after them to reimburse. But again, step 1, address it. Stop the damage. Clean up the damage. Don't let it spread. Step 1A. And 1B is, okay, who's responsible to pay for this or reimburse the association because we've already paid? Okay?
I have to ask one question, because I'm going through this right now. Where does mold fall under that?
Where does mold fall under that?
Right.
Again, well, mold is going to be part of the damage that we're talking about.
Right.
Okay? And by the way, if mold is an exception in your policy, then even though it's an association insurable event, you want to check, obviously, this is one of the things, check your policies and see what happens. If you have mold coverage or not. Because if mold is an exception, then you have the association that's going to have to go out of pocket to address that. And whether you can collect that back or not. And that's, by the way, why you want to stop this early on. Guys, you opened a floodgate. I need you. Can we hold it? Can you hold that? Can you hold the question?
No, I think we have a question.
Okay, guys, it's his fault, and I'm weak. I'm going to take one last one, and then hold the question until I get through. Let's go ahead. Go ahead, sir.
I just want to know if you can require your owners to purchase an 806 condominium house.
Okay. And see, and I was going to get to that next, so that's fine. Okay, the unit owner policy is not mandated in the state of Florida. The question is, can you as a board require all owners have an HO6 policy? You as a board may not. Unless somehow you as a board have the authority to amend your declaration without an owner vote, which is very, very rare. So it's unlikely anybody in this room has it. You can, as a board, propose an amendment to your declaration to mandate that owners have coverage. And then if the membership supports that, it gets recorded in the public record, that is enforceable. Okay? You can't force place it. You can't go out and buy them coverage and make them reimburse you the premium, because it's just not available to do that. But if you have it and it's in your governing documents and mandate, and someone doesn't have it or doesn't provide you the proof, you can and should follow up with an enforcement action, because as we get into covenants, you need uniform enforcement, and then you would pursue them and require them to purchase it. You would go after them through court, or either court action or arbitration. But it has to be in your declaration of condominium, not articles. I wouldn't have it in your articles, bylaws, and certainly not in your rules. Okay? And like I said, I'm highlighting this. Certainly, there's other information in here I encourage you to read over, but I'm highlighting the points. Promulgating rules and regulations. Okay? The association is charged with the responsibility to promulgate reasonable rules and regulations pertaining to the use of common elements, common areas, recreational facilities, and use of the unit if your governing documents grant you that authority. That's important, guys. I will. Okay? Use of the rules governing your community. You have your declaration, you have your articles, you have your bylaws. Those are recorded documents, developer created. Sometimes additional rules are as well. And typically, and for purposes of this conversation, typically can only be amended by membership approval. Rules and regulations, often the board has the sole authority to adopt, amend, etc. There are communities that I work with who do have language in it that requires the membership to approve rules as well. I think that is not a good idea, because I think that there's enough protections in the law where the board can't just go haphazard on rules, that you have to give the board members some authority to run the business. So, first step is to review your deck, articles, bylaws, and see what rulemaking authority do you have. Most of the time, if not all of the time, you will have the authority to adopt rules that govern use of the common element, recreational facilities, etc. Whether that authority extends to rules governing use of the unit will be dictated by how it's been written in your governing documents. What we'd like to see is that you have rules governing use of the capital P property or condominium building, things of that nature. If you don't have the ability to adopt rules governing use of the unit, you don't have the authority to do so. Does that mean boards don't do it all the time? Of course not. But I'm just letting you know that this is what we would be looking at. I have just since the turn of the 2020, I've had four clients who said we need our rules reviewed. And by the way, that is something you absolutely should have done if you have not had that done in the past. If the rules you have in place right now have never been reviewed by experienced counsel, I highly recommend you have that done for two reasons. Number one, you want to know the rules that you have in place are enforceable. Okay? And the way rules are considered enforceable if, one, you have the authority to adopt them, as we just talked about. Two, the rule does not conflict either expressly or by implication with the deck articles bylaws. And I'll give you a very simple example. Okay? The declaration is silent on pets. Nothing at all said on pets. The declaration articles bylaws, nothing on pets. By rule, the board says we want to restrict pets in any way. That rule is subject to a successful challenge if you try to enforce it, because the implication by the silence is that pets are unrestricted. That's a conflict by implication. An express conflict would be if the declaration says no pets, and the board adopts a rule says, no, we're going to allow you to have one dog. Obviously a conflict. That's an express conflict. But the implication is more often. So, your declaration, the declaration doesn't say anything about commercial vehicles, but the board wants to adopt a rule that says no commercial vehicles. Again, that is subject to a successful challenge because the implication is they're unrestricted. So, we look to see, do you have the authority? And how far does that authority extend? Are the rules that you have in place or want to adopt going to conflict either expressly or by implication? And 3, are they reasonable and not against public policy? And that's the second reason that we want to review these rules. One, as I mentioned, to make sure they're enforceable. You don't want to be going down a path where they're not. And 2, to make sure that you haven't inadvertently created or drafted or are enforcing rules. They're not even enforcing, they're just there, that would expose the association board members and maybe even management to liability for primarily issues under fair housing laws. Simplest example there. I see documents, I see rules that say no babies with diapers in the pool. Okay? Now, 55 and over communities, you might have a little bit of leeway, but regardless, the point is we don't want anybody in the pool with a diaper. So we change babies to nobody. You know, simply, I'll be a little more clever than that. But the point you get is a simple word change removes the allegation of, hey, you're discriminating against children with families, to saying you are now uniformly enforcing against everybody regardless. And it's those reasons why I encourage you to have your rules reviewed by counsel who understands what I'm talking about. And have them give you guidance in writing so that you can support. One of the things you might need to do to enforce your rules will be to have some amendments to your declaration. For example, if you want to have pet restrictions, you have to put something in your declaration that would allow. Okay? So when you're promulgating rules, that's important. That's the process to do so, and that's how it works. In order to adopt rules governing the common elements, common facilities, 48-hour notice posted. Dan already went over very specifically, the meeting. I'm not going to repeat the meeting requirements. He did an excellent job with that and gave you some good advice. I have some, you can read what's in here to supplement that. But it's 48-hour notice for that, and it's obviously should be on the agenda, as you pointed out. If it's rules governing use of the unit, and you have the authority to adopt rules governing use of the unit, if you want to say, you want to provide that no noise nuisance from your unit, we want quiet time after 11 p.m., for example. Or something along the lines that impacts use of the unit. That requires a 14-day notice. And that notice has to be both mailed and posted at least 14 days in advance of that meeting. Okay? And again, that notice and agenda, that we're going to consider the following. You don't have to send out the proposed rule itself. You can hone that in that 14-day window. But the notice and the agenda need to clearly indicate to the owners, and it has to be mailed into them, each of them. If they've approved electronic, you can email it to them. And also posted in the community where you post your meeting notices 14 days in advance. And then at that meeting, you would approve, again, that item comes up, a motion is made, it's seconded, there's discussion amongst the board, discussion amongst the members in attendance, back to the board for the vote. If the board approves that rule in order to be enforceable needs to be published to the membership. You need to send that out to the membership, and I would recommend that you keep a copy of it along with an affidavit of mailing on file, so that if anyone ever questions that they never got it, you have rebuttable proof that this is when it was sent out, and it goes into effect the day you've mailed it out, unless some documents will say the rule takes effect 30 days after it's sent out, for example. Okay? So that's the problem. That is the process for rules. Rules do not, for condominiums, rules do not need to be recorded in the public record. Your declaration articles, bylaws, and all those amendments do. If you record your rules, you should always record them. Okay, so if your rules have been recorded, always record them. Okay? Enforcing your covenants. Okay, I've talked already about this. You're charged with the responsibility of uniformly enforcing the governing documents, and that includes all the covenants, restrictions, and rules. If you fail to do so in a timely manner, you could waive the ability to do that. So someone asked about earlier, hey, can we require that they have HO6 coverage? If it's a covenant, you can. But if you fail to uniformly enforce that covenant, if I don't provide you that proof, and let's say the covenant says that you have to provide us proof within 30 days of a written request, and I don't provide you the proof and you blow it off, and then, you know, someone moves in next door to me and they also don't provide you proof and you go after them, what kind of defense do they have? Do they have a successful defense? Selective enforcement. Okay? You've let me go, but now you're going after them for the exact same violation. That's selective enforcement. Okay? If you fail to timely address a violation that you know or should know about, and by timely, I would say that you want to have that, if the owner hasn't resolved it within 6 months' time, it should be with your lawyer. And your lawyer should be moving toward legal action, whether it's arbitration or pre-suit mediation, which I'll talk about later on about the new legislation we have pending, or court action if that's what's required. Not just letter writing. That you actually, within a year's time of when you know or should know about that violation, you've taken some kind of formal legal action against that owner. Anything beyond a year, you now run the risk that there is a defense that they can raise that you have waived the ability to enforce. Waiver is another successful defense. So, I move in a community that says you cannot have dogs. And there's no emotional support animal in my example. Okay? Even though we have crazy, there's always been emotional support. But there's none in this example. I move in and I have a dog. And I have that dog and I walk in. Everybody knows about it. I've been there for 2 years. And now you come after me and say, hey, you gotta get that dog out. Well, you've known about this dog for multiple years. I can raise this defensive waiver and there's a good chance I'll be successful. Certainly, as your attorney, I would point out this is a risk. If you proceed, they could raise this defense, and if it is successful, which it certainly could be, you will then pay not only our fees, but their fees. So that's what waiver means. And then, so now, if that has happened, there is a way to get that ability back. Okay, anybody know the word? Republication. Okay? I know some of you definitely know it. I see heads nodding. Republication. What that means is there are covenants, rules, whatever, any bylaw provisions, whatever they are, that we have, for whatever reason, not enforced uniformly over a length of time. Okay? Now, remember, by the way, the corporation is an ongoing entity. So the fact that you are elected to the board today, and you immediately start uniformly enforcing, we've always done it, we've always enforced it. It doesn't matter if the boards prior to you did not. Okay? It's an ongoing entity. So, if you are on the board and you recognize, or you're that, hey, we haven't been uniformly enforcing certain violations, and we want to, and you want to, then you have to do what's called republication. And that is not a difficult thing. It's a board action. It's a 48-hour notice that's posted, and on the agenda, you're going to note that you're going to be republishing whatever restrictions or rules or bylaw provisions that have not been uniformly enforced previously. Okay? And I can tell you that what we do, we draft a memo. And that memo is essentially your script, and it basically says we haven't enforced these provisions, we believe we should be. Going forward, we're going to be uniformly enforcing. Any violations of those provisions will have to be grandfathered in. So, for example, if you require leases to be approved, and this has come up more often than not, then you find out we haven't been doing that, or prior boards haven't been doing that. What you'll do in that instance is you would then you republish the lease restriction, you draw a line in the sand. Going forward, anybody who's looking to lease their unit needs to get approval. If you have occupants in there now who haven't been approved, please fill out this form. They will be grandfathered. Provide us a copy of the lease if we don't already have it. They'll be grandfathered in for the term of that lease. Does it lead to the potential for people to try to manipulate? Absolutely. We have to. The bottom line is this: you have to weigh these things. I will tell you. I had one community where it had not become an issue, but they came to me asking me a few certain things, and I pointed this out to them, and they decided, well, we're not going to republish right now. It's not an issue. People seem to follow it or believe it. That's fine. My job, again, as I started, is to make sure you're fully informed. Here are your options, here's your cost benefit, here's your risk assessment, so that you can take all the facts together with the law, with my guidance, and make that informed decision. But the republication will draw that line. And you grandfather in whoever, you have these violations registered as grandfather, including my dog. Now someone moves in next door to me, and they're walking around with a dog, and you go right after them, you can't have that dog. And they ignore you, or they say, screw you, Mike has one, and you eventually end up in legal action, and they raise a selective enforcement defense. Well, you get to slap down your republication card, and you win. Because you have now drawn that line in the sand, and it isn't selective enforcement, you've started anew, and we can go after them. Okay? So I cannot emphasize enough the importance as board members of your being aware of whether you've been uniformly enforcing violations and doing what you need to do to address that. And on a going forward basis, making sure that you uniformly and timely enforce these violations. Okay? Again, 2 more quick things here, then I'm going to take questions. I'm going to have 2 more things on this. Let me finish enforcement. Okay, no, I'm just going to finish enforcement and then we're going to open a question. Okay? Authority to fine does not need to be in your governing documents. Authority to fine is in the statute. In order for you to fine, however, you need to establish an independent fining committee of 3 unit owners. Okay? In that condominium. And those owners cannot be directors, officers, employees of the association, or spouses, children, grandchildren, sisters, or brothers. You can be an aunt and uncle, apparently. You just can't be any of the other things. Okay? The fining committee's role is very specific, and this is certainly an area that has led to some confusion, but I want to point out very clearly, guys, give me your attention on this. The role when it comes to violations, the statute says the board establishes that there's a violation and will levy the fine. In order for the fine to be imposed and put down on the owner's ledger, if you want to look that way, the committee has to confirm it. So, first step is for the board to establish a fining policy. At a properly noticed meeting of the board, establish a fining policy. The statute says you can fine up to $100 per day per violation, max $1,000. Okay? If your governing documents have something less than that, you have to follow that. I see many documents where the fine is $25 or $50, whatever it is, you have to follow that. But if there's nothing in your documents, it's easiest to just go adopt a policy that anybody, the board determines a violation, we're going to fine $100 per day per violation, up to the statutory cap, which is currently $1,000. Then when there are violations that you confirm exist, letters are sent out to the owner informing them of the violation and letting them know you have this amount of time to comply. And if you fail to comply, a fine will commence. Because the board has the authority to levy the fine. If they don't come into compliance, you give them 10 days. And 10 days pass, the violation is still there. Well, now you send them that follow-up notice. Hey, violation's still there. Now you're being fined. We told you you're going to be fined. Now you're being fined. And here's your invitation to the committee hearing, the fining committee hearing, which has to be at least a 14-day notice mailed to the individual. Okay? Saying, come to the committee meeting. By the way, if you don't come, we're still going to have the hearing. And if the committee confirms the fine, you're going to owe the fine. I mean, that's not how the letter will read, but I want you to know this. Okay? But you invite them to the committee hearing. And you remind them, and you still need to come into compliance. At that committee hearing, here's how I express it, okay? The committee sits up here, judge and jury. Management team and the board, they're the prosecution. If the violator, whether it's the owner, the tenant, an occupant, shows up, and quite often in my experience they don't, but if they do, they're the defense. Association presents its case, and that's why it's important when you're saying the violations, have your letter, have your photographs, have people who have eyewitnessed it give statements or even come. If they show up, they can defend. The role of the committee is then to have gathered all the facts, the information, ask any questions they want, and decide we agree or we don't. They don't get to say, you know, we agree with you, there is a violation, but 1,000 is too much, we're only going to do 500. That's not the role of the committee. The committee's discretion lies in either, yes, we agree, and confirm the fine that the board has levied, and it is now imposed, it can go on the ledger, or to reject or deny the fine, and it is not imposed. Okay? Now, by the way, if they happen to reject it, that doesn't mean if the violation still exists, you shouldn't pursue the violation. You're just not pursuing the collection of the fine. Okay? If the violation has been come into compliance at the hearing, but the committee still approves the fine because they took that long to do it, my suggestion is put that fine on the owner's ledger, and the board does have the discretion, the board, not the committee, the board has the discretion to negotiate. The owner can say, I'm sorry, I should have done it before, it's my first offense, can we do something here? The board can agree, yep, we'll take $250 this time. For example, but that's not a committee role, it's a board role. Okay? By the way, once the committee confirms the fine, if they do, in order for the fine to actually be in effect and be put on a letter must go out to the individual and the owner, notifying them of the fine being confirmed and that they owe the amount and that they have to pay it within a certain amount of time. The statute says they have to pay it within 5 days of the committee hearing, which is just quite frankly, in my opinion, ridiculous, because you may not even give them the notice within 5 days. And we tried to get that changed in Tallahassee, and they were just bullheaded. So, whatever you decide on that. Okay? So you have to. But I just want to be clear. Board levies. The board says in violation levies the fine. If you have a fining committee, if you don't have a fining committee, forget fining until you get a fine. Either way. Whether you have a fining committee or not, the violation still needs to come into compliance, which circles back to my point earlier, that if it's still in violation and the committee's confirmed the fine, then you're still following up with the owner, here's your fine, and you still need to come into compliance, and if they haven't, it's coming over to council, you're sending to council all the backup for the violation and all the backup for the fine. And now, so what we would do in that is, it's a 2-count complaint. We say to the owner, come into compliance and pay this fine. And if they don't do them, and we go for legal action, it's 2 counts. 1, for the violation to correct it, and 2, to collect the fine that they've been imposed. You may not lien for a fine in a condominium, period. Okay? The reason, by the way, I say put the money on the ledger, if you so choose, even if they've come to compliance, is if any owner owes any monetary obligation to the association, including a validly imposed fine, you can suspend their voting rights, and/or they would not be eligible to be a candidate to vote. So if someone is not following the rules, regular restrictions, and you have to fine them, again, the committee confirms the fine, then even if they've now come into compliance, if they're not willing to pay up the fine, whether it's the full amount or negotiated amount, and you're not willing to waive it, it's on the ledger, and you can use it in those capacities. You can suspend voting rights to for any unit owner who's more than 90 days delinquent, but also has to be of 1,000 or more. So, keep that in mind. All right? That is collection of assessments and special assessments. I'm simply going to remind you that is all we mentioned earlier. 2 responsibilities: pay your assessments and follow the rules. People aren't paying their assessments. You should have established a policy or procedure, board policy or procedure, with your management team for how long you're going to give them to be delinquent before you're going to refer them to council to start collections. Okay? I will tell you, under the law, first thing we have to do is send a 30-day notice that we are going to lien, a notice of intent to lien, and we give them 5 days for mailing. If they don't respond satisfactorily, we have to do a second 30-day notice with 5 days for mailing of intent to foreclose, meaning now we're liening your unit, and if you don't address this, we're going to move to foreclosure. So there's a minimum of 70 to 80 days before it can go to foreclosure once you send it to a lawyer. If you're giving them 6 months, and then you're sending it over to the lawyer, remember, we're going to have to give them another 3 months. So when I talk, people say to me, what do you suggest? I mean, it's a business decision. But my suggestion would be to look no more than 45 or 60 days. Okay? Payments due on the 1st, they know it's due on the 1st. Your management team likely sends at least 1, if not 2, courtesy notices. By February 15th, which is 45 days in my example, they haven't paid January or February. You refer them to me, we're getting that first letter out, but that's going to take us through February and March. Second letter is going to take us through April and into May. We're not even looking at foreclosure. We're not even considering foreclosure until they are 5, almost 6 months late. So nobody's rushing to foreclose. Owners have more than enough opportunity to reach out to you first, and then to the attorney second, to address these things. And if they don't, for whatever reason, it is not your responsibility or your obligation or your fault. Okay? All right. Special assessments, real quick. If you are going to be considering special assessments, Again, the reason for the special assessment needs to be known. Some documents do require membership approval for special assessments. I mentioned earlier, if you're doing a special assessment to address necessary maintenance, notwithstanding the fact your documents say approval is needed, you do not need it. Get an opinion from council in writing so you can feel good about that. But it is a 14-day notice of a board meeting that is also mailed and posted. Okay, 14 days in advance, that the notice is posted 14 consecutive days, at least 14, and is mailed or hand-delivered to every owner at least 14 days in advance, and that notice has to indicate very clearly, we are going to consider a special assessment. It also has to say why, what's the purpose of that special assessment, and give a reasonable estimate of what the assessment is going to be. It doesn't have to be exact. By the time you get to that meeting, you should have those numbers broken down. And at the meeting itself, that's when you want to go over the breakdown. You want to clarify in the motion what the amount of special assessment is going to be, what the payment options are going to be, whether you're going to accelerate it if you're giving installment options, whether you'll accelerate, how you want to handle it in case of a sale or refinance. All that is in the motion, and you get with your counsel, and you get with your manager, and you review that, and you make sure the notices are proper and the motion is proper. But for step one is that 14-day notice. Well, step one is making sure you have the authority to do it. Step two is making sure the 14-day notice and that the notice contains those three items. Hey, we're going to have a special assessment at this board meeting for this or these purposes, and this is what we reasonably estimate the special assessment is going to be. Okay? So with that, let me take some questions on anything I've discussed thus far, because this was the biggest topic. Do you have a question? Yes? Okay, the question is, can you make a building smoke-free? Just the common element area. Okay, that's a good distinction, okay? The board has the authority, assuming the board has the authority, to adopt rules governing the common element. If you do, and most of you likely you do, then the board by rule can restrict smoking in the common element areas. Yes, as long as the rule is properly passed and properly sent out to all owners, as long as all proper procedures are followed in accordance with your governing documents, then the board would have the authority to restrict smoking in the common element areas. You do not need an amendment to the declaration. I have buildings who want to restrict smoking in the building units as well. That requires an amendment to the declaration, approved by the membership. I'll repeat it.
Regarding getting smoking prohibited in the common areas. Let's say, just say for discussion's sake, I own a condo. My board decides to put a rule in, no smoking in common areas. I'm now selling my condo. Do I have an obligation, or does the realtor have an obligation to inform the prospective buyer that they're moving into a building that has no smoking in common areas? Thank you.
You have an obligation. You have an obligation to provide a full set of the governing documents. Well, it is. If it's in the rules, that's part of the document. If the documents don't speak of smoking, restricting smoking, in other words, if there's nothing in the declaration, articles, bylaws, or rules that restrict smoking, then what are they enforcing? No, I'm saying, but again, I mean, that's like saying, if there's no rule that says no diving in the pool, can we dive in the pool? Yeah.
I don't know how many there are. Thank you. Yeah.
I was listening to you in the beginning, like he's a nice guy.
They did put a written rule. But that's my point. The board has a written rule that's been published to the membership saying no smoking. Okay, yes, it has to be published and it's in your rule book, presumably. So when you have someone who's buying, one of the obligations is you're giving them a full set of the governing documents. It's their responsibility to review them. Okay.
Okay, when you say mail, is email acceptable with a receipt that you email
Okay, the question is, when I said mail, is email acceptable? Receiving notices by electronic transmission or email is acceptable if and only if the owner has consented to receive notice in that way. If they have not, that doesn't mean that you can't, that if they have not officially done so, because if they have to officially do that, because that makes their email part of the official record, which is a brief discussion we'll have later on official record. So the answer to the question is, it's only considered acceptable in lieu of mailing if the owner has consented in writing, and that can be by email, hey, I want my notices sent to me via email, you don't need to mail them.
What if they're out of the country, they live in Canada?
Doesn't change it.
Okay.
That's the reason why, the way, I got you guys, that's the reason why they've also implemented something called electronic voting. So that if people can vote electronically if you properly implement that. Okay, yes? 1, 2, that's the back table. And then I'll come over here.
Florida law, for example, says you need 48 hours to notice the meeting, but our documents say 72 hours. Florida law supersedes.
Okay. The question is, if Florida law says 48-hour notice for a board meeting, but your document says 72. I will say this. I'd be surprised if your document said you have to notice the membership, 72. What it usually says is board members are required to be given 72 hours notice. Quite frankly, I'd be surprised. If your documents, though, said that 72 hours notice for membership, I would follow that. But my understanding is, and when I read these, is board members are usually required to be given extra notice. And usually it'll say 72 hours or 3 days or 5 days, and it can be done by phone. You can phone them up and say, hey, we're having a meeting, and then post it.
We post the agenda, for all of them.
Correct, and that's minimum 48-hour notice for the general membership. Board members, you may need to notify them a day before that or 3 days before it. I'm thinking that's probably your 72 hours is.
My question is, we have already terminated.
I will come over there. I said 2 more there, then I'm coming there.
Our condo has an exterminator, and we request everybody, we have 96 apartments, to allow him to come in at the right time. What do we do when there are people who say, no, I don't need them? And what do we do with tenants that say, I don't need them?
Okay. So the question is, they have the association has does extermination on all units, and there are owners or tenants refusing access. Well, that's a situation where, assuming your documents give you the ability to do that, that's that right of access. You have the right of access to go in and address maintenance of the common element areas. So if you're going in and treating the common element or areas that you're responsible, the owners have to give you access. Now, an owner may provide medical documentation that says, hey, this stuff you're spraying is going to be problematic. And that's a case-by-case, fact-specific situation. But in general, if they are not allowing access, that's a violation. And I'm not suggesting you force your way in, but you certainly should be engaging with counsel and asking counsel to assist you in resolving this, preferably amicably, without the need for further action.
Should we send the inhabitants letters about that? If you don't allow the extermination to come in, he has a special day, the first Tuesday of the month, we as a board are going
You have a few issues. But the idea is we have the right of access. You need to allow us in. It's not your violation. I mean, among those things are if we don't get intervened and there's an issue with pests, you're now responsible for any damage it causes. I mean, there's multiple ways that we can go about addressing it. And like I said, that's probably not a bad idea to bring to council and get guidance so we can, brainstorm and how to put that letter together. And encourage. Wait, someone else had a question, or was it the same one?
No, the question is, who is the counselor?
No. You're a lawyer.
The lawyer, okay.
Yeah.
Thank you.
All right, I'm going to go back here, then I'm coming back. All right, guys, we're going to go quickly around, and just keep it on what I talked about now. Hey guys, listen, I do want to obviously there's a ton of questions. By the way, that's why tonight's program is great. So I want to answer questions on the materials. I'm not going to get into the point. I don't have the time to be able to get in depth with everything. And I would love to be able to take Q&A forever. I do have to hit these materials. So let's try to rally through. And if these are questions I can hold to the end, I'll stick around a little bit at the end. have a certain deductible. If you obviously have to pay your deductible, that's going to be a common expense that all owners are obviously paying through their assessment.
You didn't mean anything.
I didn't get nothing left.
Possibly a hot topic. Most of these condos, homeowners associations, were created or discovered the term emotional support. And in our particular area, we allow up to 50 now. However, 35, 15, however you want to do it. However, the rest of our community, you're probably most of them are banned. However, some of the areas where they're banned actually have more dogs than the ones where they're allowed.
I don't
Because
hear.
they're all claiming support. Now, I've noticed that even the feds are starting to get involved, the airlines are starting to get how do we deal with that?
Okay, the question is how do we deal with emotional support animals? That's an entire subject. That is definitely not something I'm going to be able to address right now. Okay, I'm sorry. I did an entire, we just 2 weeks ago, we did an entire class in our local office on that topic.
Mr. Bender, please stay there.
What?
I need to hear.
Okay, and everybody, okay? Emotional support animals is the question, how do we deal with them? And what I said was, I can spend an hour just talking about that. It is not a simple answer. I will tell you that it's my understanding that HUD, Fair Housing out of DC, are supposed to be coming out with new guidelines next week, fingers crossed, that will allow us to hopefully better address fraudulent activity in that regard. But until we see that, and I also will tell you there's a bill in our legislature, House Bill 209, which is also addressing emotional support animals and trying to limit the fraudulent activity with that regard. So if you want to go on to Senate.gov and look up House Bill 209, that's a bill that we are through CAI, Foreign Legislative Alliance, pushing to get through. We're looking for HUD regulations. But again, I will simply say this. When you have a situation where someone is claiming, either verbally or otherwise, that this is a support animal, you do not treat it as a violation. You treat it as a reasonable accommodation request, and you handle it accordingly. And that means you should be working with your legal counsel. You should not lean on your management team to give you legal advice when it comes to fair housing issues. They can certainly give you business guidance, and their experience in that regard, but they will tell you, I'm not your lawyer, this needs legal guidance. Okay? All right, a couple more guys, and I'm going to jump back in, and I'll take the questions after. Yeah, one, two. Yes. You cannot leave for a fine, correct? At the time they go to sale, can you put that? I would say, when they go to sale, that's something you can note on the estoppel of the payoff, that they have this outstanding fine. And if the violation still exists, you notify the violation still exists too. Yes, sir. Make sure that everything was properly done and can be properly supported then. Otherwise, now you run into, if not, you run into a situation where they challenge and now you're hindering a sale. So be very careful. Yeah, you're asking really great questions, but these are not like 2-second answer kind of questions that are focused on the materials. These are questions that we talk about at the town hall. These are just topics that we get into and then we stem from them. The answer, the question has to do with, hey, we have a claim, or you say your hand down, I saw it. We have a claim, we filed it with the carrier wants to settle. Well, of course they do. I mean, and the fact is, and what say you have? I mean, it's possible if they want to settle and you say, well, we don't want to settle, they may say, well, here's what we're willing to do. and anything, if you don't resolve it, then you're going to have your own exposure. It's going to have to be dialogue. It's a case-by-case type approach. It depends on how your policy reads. But for the most part, the carrier, they're going to look at the cost. Hey, it's going to cost $100,000 to take legal action on this, and we may or may not win. If we can sell it for 25, we're going to pay out 25. All right, guys. I know, listen. It's 11:16. I will take 1, 2, 3, 4, 5.
6, 7, 8.
No, 5. Make them please specific to the topics if you can. If they're not, I'm saying, and I don't need to be, I know disrespect, but I want to give you guys the information.
I'm still confused about the board being able to make the building rules. Can we do this without evidence-based talking, whatever, just
The board has the authority to
go
adopt.
to an attorney.
The board has the authority to adopt rules so long as your governing documents give you that authority. The authority to adopt rules governing common elements is most likely in there. Whether you can adopt rules that govern use of the unit will be depending on how expansive the language is in your documents. My recommendation to go to your attorney before you approve the rules is to make sure the rules that you want to put in place are going to be enforceable and are not going to expose you to liability.
Okay,
Thank
so how do we collect?
I don't know what that means.
How do we collect this fund? How do we, I mean, I have problems where we cannot collect, we tell them this is what you owe, you owe this, you owe this, you owe this.
If people owe money and you believe they're not,
Non-legend.
okay guys, and I'm not doing this to be self-serving. You need to reach out to your attorney. This is why you're running a business and you have legal issues. Guys, this is the point. Talk to your management team and get business advice. That's why they're there. But these then become legal issues, and that's the reason why your budget should have a line item for legal, and why you need to then reach out to counsel. And have counsel that you're comfortable with, who can reach out, who can give you answers in a quick way, who doesn't nickel and dime you for everything you need. But you need to reach out to your counsel and not be afraid to do so. Guys, I need you to make the question quick, real quick. Yes. The question is whether you can put up a material alteration and claim, hey, it's necessary because it's a safety issue. That's not a yes or no. That's something that would have to be analyzed because I'll give you a very quick example. I had a community that had a parking structure. They installed a gate because there was no gate because they had documented burglaries and attacks in the parking structure. They can claim, hey, this is necessary to prevent further attacks, further thefts, and also exposure and liability association. So there's an example, all right? Guys, quickly. Go.
Can you fire a board officer without a board meeting with telephone?
If the board, first of all, you cannot, the board does not have the authority to kick off the director. Okay, the board has the authority to reorganize their officers at any time. You want to change president, vice president, secretary, treasurer, you can do that at any time, but it should be done at a properly noticed 48-hour agenda item. Guys, I'm going to ask you to hold it. Okay, very specific, fact specific. Anybody with a general question? Last one. So, and you, sir. I know you still at the end there.
Do we have the right to go into an abandoned apartment if we suspect that it's not an air conditioning?
Yes. Yes, 100%. That is the statute, that was what the statute clarified. If you have a unit that's been abandoned as defined defined in the statute, meaning that it's been vacant for more than 4 weeks or more than 8 weeks if it's a tenant, and you have no reason to believe anybody's there, and you've made a reasonable effort to find someone who can get access. Well, then you should be reaching out to the bank. Okay, and if the bank is not responding, when a bank takes title, they're an owner like any other owner. And if they're not responding, they have maintenance responsibilities, and then you have the right to go in and, again, you should get advice of counsel, follow, I mean, you'll have counsel, you can write the letter to the bank, you know, but then you go in and try to, that's exactly why the statute was changed. Sir? Alright, well, contracts is the last subject matter, so we'll answer it then. Alright, budget and reserves, guys. We're going to page 9. Board meetings you're ready to discuss with Dan, you can read over there. Budget and reserves, I'm going to go through rather quickly, although it's very important. Most of the items for budget and reserves you will work with your management team on and maybe your accountant. On page 9, we talk about sections of the budget, and we have operating expenses and the reasons for operating expenses. Operating expenses obviously are what you anticipate being your day-to-day, week-to-week, month-to-month expenses to run the business that year. Not expenses that are going to be once a year or once every 10 years, something of that nature. Generally, what you anticipate you'll need for the year. Okay? Reserves. Okay? Florida statute requires in your Condominium Act that when you adopt the budget, you adopt the budget with statutory reserves. Fully funded statutory reserves. Okay? Right now, reserves must be established for roof replacement, building painting, pavement resurfacing, and any other deferred maintenance, replacement, or capital expenditure item that you expect to be over $10,000. The cooling tower, the elevator, the pool, those are other things that you might have. Okay? Sidewalk. Okay? The formula for computing reserves is set forth. Okay? It's very, you have your total estimated useful life, the remaining life, your total, so we think the roof's going to be a 20-year roof. We've got 10 years left on the roof. It's going to be $100,000 to replace this roof, and we have nothing in reserve. So to fully fund that reserve account, we need to put $10,000 away for the next 10 years. That's the formula. Okay? Does anybody here need pooled reserves? There's two types of reserves. There's straight line that I just went over. Reserve line item for paving, for painting, for roof, for elevator. That's straight line. Anybody doing pooled reserves? Okay? I'm not going to talk about what you do. Are you comfortable with pooled reserves? Okay. Because pooled reserves is an option, and it's talked about in here, that pooled reserves essentially says instead of straight lining, we're going to take all the money, throw it into one big reserve account, and then whatever we need, we can take from the reserve so long as it's one of the items in the pool. In order to do, quite frankly, if you've not done a reserve study in the last 3 years or more, I recommend that you get a reserve study done so that you can properly establish what your reserve should be. If you're doing pooled reserves, you absolutely have to, because they're going to then let you know when you're doing the reserves how it works as far as what you should reserve each year in the pool, because they'll tell you, hey, in 5 years we expect this to go, in 8 years this, 10 years this. Okay? With regard to reserves, if as a board you want to fully fund reserves, and I have to emphasize this, guys. If as a board you want to fully fund reserves, I won't say that. Hey, guys, quiet. If you want to fully fund reserves, okay? In order to fully, the statute, as I told you, says fully fund. If the board says we believe it's important we fully fund reserves, if the board says we want to fully fund reserves, that is within the discretion of the board. The board does not have to put out a vote to waive or partially fund reserves. That is a business decision for the board. Legally, totally fine. Politically, maybe not. But legally, you, the board, can say, you know what? We didn't reserve the last 10 years. We think it's important we reserve, and we're going to fully fund. If, however, the board wants to do something less than fully fund, partial fund in any way, or waive, that's where you have to go out to the membership and ask the membership to approve it. And the vote you need to approve of less than fully funded, either partial or waive, is a majority of your quorum. So in the Condominium Act, quorum is a majority of all owners unless you have a lower percentage in your documents. So let's say you're 100 units, majority quorum's a majority, that's 51. You would need at least 26 of those 51 owners to agree on the waiver or partial funding. Obviously, if 60 people voted, you need 31, and so on. Okay? If you want to use funds that are reserved for a particular item, for a different item, say you have $100,000 in your roof and only $20,000 in painting, and you know you don't need to do the roof for 10 years, but painting's done now, and you don't want to special assess, you can go to the membership and say, hey, membership, we'd like to take $20,000 from the roof reserve to supplement our painting so we don't have to hit everybody up. Same vote, majority of the quorum. So in order for the board to fully fund, board discretion. To partially fund or waive, or to use reserve funds for a purpose other than what they've been designated. That requires a vote of the membership and majority of the quorum. Clear? Okay. With regard to your budget, the budget is another board meeting that requires a 14-day notice. Okay? So that most board meetings, you know, are 48 hours, but if you're doing a special assessment, if you're adopting a rule governing use of the unit, or when you're adopting your budget, or if you want to do electronic voting, you have to have a 14-day notice that you're going to do that. Okay? But those are four. So if you want to adopt your budget, when you are ready to adopt your budget, it's a minimum 14-day notice that has to be mailed or hand-delivered and posted along with a copy of the proposed budget. Okay? Again, your management team is well aware, but you all should be aware as board members, okay? And that proposed budget goes out with a notice, and at the board meeting, that's the agenda, and you can discuss, and yes, you can make changes to the budget at the meeting itself, based on your own thoughts and discussions, based on comments from the audience. And then you approve the budget, and it's put in place. Okay? The next section in page 12 is financial reporting. Okay? I am not going to get into that. It's rather straightforward, but you have 3 requirements for reporting that are all spelled out there, and just be aware that you have to, those are 3 different filings that you must be doing. You have an annual financial reporting requirement. You have, and it goes over the financial reports. You have, and then you have governmental financial filings. And by the way, even though you're not for profit, you do have to file taxes. So make sure your accountant is on top of that every year. Okay? The only thing I'll say about your annual financial reporting requirements is you do want to, as board members, it's your responsibility to make sure these are getting timely done. Okay? Within 21 days after, within 90 days after the end of your fiscal year, or annually if there's another date in the bylaws, you have to have a financial report completed. The level of that financial report will depend on your revenues unless your governing documents, and typically it's your bylaws, specifically require an audit. If your bylaws say an audit, then you should be doing an audit every year. If you don't want the expense of an audit every year, then you should amend the bylaws to provide for, remove the word audit and put in your financial reporting requirement as provided by Florida statute, as it may be amended from time to time. If you look on the bottom of page 12, top of 13, it goes over the revenues. You can do reported cash receipts and expenditures if you have revenues less than 150. Compiled financial statements, reviewed financial statements, you're mandated for an audit if it's total annual revenue of 500 or more. Or if your bylaws say an audit. Okay? All right. I want to talk about record keeping and unit owner access to records. Okay. Again, this to me is one of the biggest subject matters that comes up, and it's something that is challenging to your management team as well as to you guys as board members. Okay? You are required to maintain certain records as part of the official records of the association. I have spelled out a long list of what they are. Except for ballots and voting proxies and any other papers relating to voting by the unit owners, which have to be maintained for 1 year, all of the records are maintained for 7 years. Except, as of July 1st, 2018, your minutes of all your meetings, board, committee, membership, must be maintained forever. Okay? So, basically, if you go back 7 years from July 1st, 2018, you should have minutes going back 7 years because you're supposed to maintain it for 7 years. But then in 2019, now 2020, you should still have those minutes from 2012. And as we go, so minutes are to be maintained forever. Okay? As well as obviously your governing documents, but that's self-evident. Unit owner access to records. Okay? The statutes do grant each owner or authorized representative of the owner the right to, excuse me, inspect and copy records. At the expense of the unit owner. Okay? And as long as these records are not subject to an exemption, attorney-client privilege or otherwise confidential. Okay? The board must make records available to the unit owner for inspection within 10 working days of your receipt of the written request. And if you fail to do so, it's a rebuttable presumption that you're willfully withholding, and you can be subject to penalties of $500 that you have to pay to that owner, not to mention some other penalties from the division if its complaint is made. Here's important, guys. The board may adopt reasonable rules governing frequency, time, location, notice, and manner of record inspection and copying. The statute gives you discretion. I suggest if you don't already, you should have them in place. And again, with rules in general, you should have them reviewed by counsel to make sure what you're doing is enforceable and not going to expose you to liability. Okay, but rules, you should have rules in place. I will give you 2 examples of rules that I think are good, and I think they protect both the owner and the association, and I've been told by the division they're enforceable. Number 1, any request to inspect the records must be by certified mail. Okay? This stops owners from just zipping thousands of emails to you or your manager. It stops them from it requires them to go certified mail. It also, though, gives them a record of when you've received it, so they know when they can support when the clock's in. And it puts you on your toes because you know when it was received. You have 10 working days to make sure they can have access to them. Okay? Number 2. No request for inspection can be made more than once in any 6-month period if the document is something that is not changed. So, if someone says, I'd like to see the bank statements from 2018, today, they can't request those documents for another 6 months because the bank statements haven't changed. These are just 2 examples of things that have come up, and so you try to address, reasonably. Owners have the right to see the records. And if they want to come in and see the records in the ordinary way they're kept, they should. I will tell you, you have no obligation, neither you nor your management team has any obligation to cull through records and try to figure out what does this owner really want. In fact, I can tell you a true story where I had an association that tried to do just that. They tried to be nice, they got a request for inspection, specifically certain documents, and they tried to pull these documents. And when they didn't pull everything out that the owner wanted, the owner then complained that you willfully withheld, and they were found to have willfully withheld. Now, I completely disagree with the result, but ultimately it reiterates, it underlines the fact. If someone makes a request to inspect, if someone says, I want you to mail me a copy of these, you can ignore it. I don't suggest you do. You can mail it to them. I don't suggest generally you do, depending on what it is and who it is. But I think the third thing is what I would do, is that you can respond to them. No. Essentially, we don't have any responsibility or obligation to cull through records and find what you're looking for, no matter how specific it is. However, the records are available to inspect. Here's some dates, some times. Let us know what works for you, and we'll be happy to let you review. And if you want copies,
It's gonna be 25 cents a page or whatever it is, you know, and you can pay by cash or check. And obviously, if they pay by check, when the check clears, you give them the copies. Okay? All right, so be aware of these things. Okay? But if someone wants to bring a portable device with them to make copies, they are allowed to do so without charge. So they want to bring in a phone, a scanner, you know, anything that they want, let them plug it in. I had someone say, can we charge them for the electricity? No. But they can do that, and they can do that. Records, again, and by the way, the records should be done, allowed to be expected in the way they're kept. So if you have them in file cabinets, and you don't want them in your file cabinets, then you have to take the files out, put them in a box in the way they're kept. You can't just take a bunch of things and throw them on the table, you know, mishmash, and say, go ahead, that's not going to work. Okay? Certain records are not accessible for inspection, as we spelled out here. Medical records of unit owners is a big one. You have emotional support animal requests, things of that nature. Any information you obtain in regard when you're reviewing their accommodation requests, it's all confidential. It's in a file under official records that are locked, that should not be exposed to any owner. And in fact, you don't even have to allow all board members. That's up to the board to decide if we're going to give all board members access to these records or only those who really need access. Okay? Any information you obtain in a sale lease application should be locked away, confidential. Obviously, the most obvious in it is attorney-client privilege. Attorney-client privilege communications. We provide guidance, we provide opinions to you. Those should not be shared with the membership unless you communicate with counsel that you're going to share with the membership. Okay, when you ask for an opinion from counsel. So if you're at a board meeting and someone says, hey, what about XYZ? And you say, you know what, I'm going to get an opinion from the counsel on that, or attorney on that. Well, if you do that, then you basically said to the membership, I'm going to get an opinion and share it with you. There was a case that came out on that. So if someone says, well, who's responsible for maintaining blah, 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 don't say I'm going to get an opinion from counsel. Say we're going to look into that. We'll review it further. Then you can come and get an opinion from counsel, and you can then get that opinion and decide what or how you're going to share it. Okay? Because the board does govern the community. The board is who, when we're hired, we represent the association, and everything we do is in the best interest of the association. But we do take our direction, our instruction from the board. The client is the association, but the board is who has the attorney-client privilege right. Okay? So, personnel records of management or association employees, like disciplinary health insurance records, all confidential. Employment agreements with an association employee, those are accessible because they're contracts. Okay? The association is not going to be responsible for the use or misuse of information that's made available to a unit owner, as long as it's supposed to be, or their authorized representative pursuant to a request for inspection, unless you have an affirmative duty not to disclose. So that's why it's important to keep the confidential information confidential. But someone says, like if someone comes to a board meeting and says, who's delinquent? I want to know. Please don't stand up and say, that one, and that one. Or even say, well, it's Jane and John and unit 101. You don't do that, period. If someone says who's delinquent, what you can say is, well, if you'd like to go to make a request to inspect the records, you can get a delinquency list, and you can see for yourself. Okay? Now, if that individual decides to go ahead and start posting that around the neighborhood, I recommend you should take them down as soon as you see them, but that individual could be responsible. Okay, those owners might have a personal action against that individual. The association would be insulated in that regard because they would have had a right to that document. But if you give them someone's medical records and then they're sharing medical records, you're going to have a problem. Okay? By the way, as of July 1st, 2017, a renter has the right to inspect and copy bylaws and rules. That's it. So a tenant can make a request to inspect the records, but all they can have is the bylaws and the rules. Not your declaration, not your articles. I don't know why, but that's how they pass it. Okay? Yeah.
There's a workshop, our neighborhood has a workshop every Friday with the board of directors. So those minutes have to be taken and recorded to the unit owners.
Okay, hold that thought. I will address that before we leave. Just make a note of that. So thank you, that's a good question. Okay, websites. Okay, Websites are for condominium, website mandate is for condominiums with more than 150 units. How many of you are condominiums that have more than 150 units? Your condominium, not your association. And this is what I mean by this. They changed this. When it was first adopted, it was any association with 150 or more units. They specifically changed the word association to condominium. So what that means, if you are 10 buildings in the community, okay, it's ABC Corporation, and there are 10 buildings, one board of directors, 10 buildings, but each building has its own separate declaration of condominium. Okay? That means those individual buildings have to be 150 or more units in order to be mandated to have a website. So if each building is 20 units, and in total you're 200, when it was first passed, you needed a website. When it was revised, now you don't. In that same example, you have 10 buildings, one association, everyone has the same declaration. It's more like a phase, if you will. That community would need no website under the statute. Now, do know this. I personally think a website is a great idea, as long as you can properly manage and maintain it, etc. I don't have a problem with websites. My issue is with the state mandating it to us. You know, I think they should give discretion to the associations, to the communities to say yes or no, like an opt-out. You know, we don't need a website because nobody's really going to use it. But the bottom line is if you are a condominium with 150 more units, you do have a mandate to have a website. It should already be up. It's from a year ago. There's a list of documents that you should have on there. There is the statute specifically provides what should be there and when. And I would recommend if you are one of those condominiums and you don't have a website, then you get with your management team. If you have a management team, you get with your attorney and figure out what you got to do. You can get referrals to people who help you do these websites. And also be aware of what needs to be up there and what doesn't need to be up there. Okay? I'm going to go on to elections. How quick?
In your documents, and our attorney said that we have to go on the website, we have to post a full contract. But I think the law says that only a listing of such contracts is now required.
Yeah. My understanding, I know they tweaked the law, I'd have to quite frankly look at it. I know that the law, my understanding is that any contract that the association is a party to is supposed to be up on the website. If the association, what you can post an itemized list of is your bids. You can do a summary of bids. But I know they made some kind of change and now it's almost conflicting or confusing. So do me a favor, but at the end, bring what you've got on there. I'll look at it and I'll let everybody know. Is that okay? Thank you. No. They're going to kill me. Okay? Elections. But I think, listen guys, we've got another at least 30 to 40 minutes and I think I have just a couple more sections to get through and so we're definitely going to have time for questions. All right? Elections I want to talk about also briefly. The condominium elections are pretty straightforward, guys. The statute says what you have to do. The administrative code, the Florida Administrative Code supports it. Okay? So the bottom line is, you have the first notice you need to mail out 60 days in advance, and that notice has to give out a notice of intent to be a candidate form. And if you want to be a candidate, you must have that form back to wherever you're instructed it has to be by the deadline, and the deadline is 40 days prior to the election. So basically it's a 20-day window. There is no discretion there. If that 20th day falls on a Sunday, you can't say, oh, I'll do it on Monday morning. You have to have it in. So if you're interested in running for the board, the moment you get that notice, send it back. Just get it back. And if you're really concerned, have a record, send a certified mail, or go into the office and get someone to sign a receipt that you did it. Okay? The second notice is that then if you want to provide a candidate information sheet, it's a single sheet, one-sided, 8.5 by 11. Okay, this issue came up a couple of times just recently. Single sheet, one-sided 8.5 by 11. And the association has no ability to edit it. You can say whatever you want in there. Okay, but do understand if you say certain things that are libelous or defamatory, that could expose you, because it's going to be published to third parties. So just be aware. I mean, obviously, but the association can't say, oh, they're attacking the board, they're saying untrue things. That goes out with the mailing. Okay? Any of these election mailings should not contain any documentation or indication of support for one candidate or another. Independently, you can go ahead and send out promoting your slate, whether you're an incumbent slate or a challenging slate. But in the first notice, second notice, those mailings, just the documentation. Just the first notice with the candidate information, the notice to be a candidate, and then the second notice, that candidate information sheet has to be given within 5 days after the deadline, meaning 20 days to get in your notice of intent, another 5 days to get your candidate information sheet, and then anywhere from 14 to 34 days is when that second notice package goes out. If the number of seats that are available, the number of candidates that they put their name in are the same or less than the number of seats that are available, there's no election. Simple as that. The second notice goes out, revised to say we're just going to seat the board, and then if we have a quorum, we'll go through our business, and then they'll close the annual meeting, unless there's other things going on, reserve waiver or amendments or things of that nature, and then we'll close that meeting and open up a board meeting, the organizational meeting of the board, where the board alone will decide who are going to be the officers. Okay? If you want to be a candidate on the ballot, at the time the candidate sheet is due, which I told you is 20 days after that mailing, generally, or 40 days before the date of the election, you must be current on that date. If you are delinquent in any monetary obligation, and I'm talking pennies, and I've seen the division support that. If you are delinquent in any monetary obligation, your name should not be put on the ballot. Okay? That's what we're talking about. We're talking about if you are elected or appointed to the board, you have to fall 90 days delinquent. Or have a delinquent balance for more than 90 days, and then you automatically abandon your seat on the board. But in order to run for the board, at the time the candidate information, the notice of intent to be a candidate is due, if you have any delinquency, your name should not go on the ballot. So if you have any doubt, you should check with your management team and make sure you are 100% current at that time. So that, or if not, you can address it so you can run. Okay? There is no quorum requirement, by the way. It means I go to many annual meetings, and it's rare that if there's nothing but the election going on, you might have 60, 70% of the people vote, even 30, 40% of the people vote, but nobody shows up at the meeting, or a handful. So the first thing I always tell them is, guys, we do not have quorum. And before everybody gets all upset, that doesn't mean anything, because in order to have the election, quorum is not relevant. In order to have the election, we only need 20% of the owners to submit a ballot. 20% of those owners who haven't had their rights suspended. So as long as 20% of the owners have submitted a ballot, the election goes forward, regardless of whether there's quorum. Okay? With regard to eligibility, the bottom is 17. Okay? Florida law does not require individual board members to be members of the association to be eligible to be on the board. Florida law does not require that. Your governing documents very well might and likely do, but if they don't, and you want to limit who can serve on the board to someone who lives in the community, someone who owns in the community even, that has to be done by amendment to your articles and bylaws. And let me just quickly, just to put this in your head, by the way. If you're ever considering amendments to your bylaws, make sure whoever you're working with recognizes that you have to review your articles as well. Far too often, I've gotten, clients have come to us with documents where they made amendments to the bylaws. Prior councils, they didn't work with prior council. I'm not talking about they did on their own. They worked with prior council, and they've done amendments to bylaws, but they didn't amend the articles. Remember, the first thing I said, the word of report was declaration, articles, bylaws, then rules. Articles supersede bylaws. If you have a conflict between your articles and your bylaws, the language in the articles controls. So if you go ahead and make a change in your bylaws to say that in order to serve on the board, you must be an owner. And then you look at the articles doesn't require that. Or what I actually have seen is they've amended bylaws to say no corporate ownership. but the articles allow for corporate ownership. That amendment, that bylaw amendment really is, to me, it's subject to a successful challenge. And you can go and enforce it a lot, maybe others maybe not figure it out, but the problem is that's just, it's a little sloppy. So be aware if you're ever amending your bylaws to make sure your articles are being checked to make sure. I like if ever we have to amend the articles at all, just to simply say, see the bylaws. So we never have to touch the articles again. Okay, just something to pop. Okay, so but with regard to eligibility, I talked about you have to be current. If you, in the unlikely event you've been suspended or removed by the division, then you're not eligible. Or if you've been convicted of a felony and you have not had your rights restored for 5 years. Other than that, you will be, as long as you are an owner in the community, you'll be eligible to run. And if the documents do not require you to be an owner, if they allow you to be a spouse of an owner or a tenant, then that's what your documents allow. Okay? With regard to term and numbers on 18, unless your bylaws or articles provide for a different term, board members serve for 1 year. As of July 1st, 2018, you might have heard, Section 17.112 2B2, a director may not serve for more than 8 consecutive years unless approved by 2/3 of the unit owners voting or unless there aren't enough candidates. Obviously, if there are not enough candidates, it doesn't matter. You put your name in. That doesn't mean you can't have your name on the ballot. Let's be clear. You can have your name on the ballot. And if there's not enough candidates to even have an election, it doesn't matter. You just keep going. But if there are if there's a 5-member board and there's more than 5 people who put their name in, the question is, you've served more than 8 years, is this prospective or retroactive? And I'm just going to tell you it's prospective. Prior service does not count. We have tried, we did last year, we had a bill that will clarify this in Tallahassee. It didn't go through, and not because of that, just other things fell apart, but it is in our bill. It's House Bill 623, which is our flaw bill, Florida Legislative Alliance bill. It's the community association bill that we're trying to put through, and people keep trying to pick at it and add things to it. But we want to clarify that it is prospective. So the bottom line is, your 8 years will start if you served July 1st, 2018 going forward. This will not impact you until 2026. The division initially felt it was retroactive. I've been told, although I haven't seen it in writing yet that I'm aware of, I know I haven't seen it in writing, but I've been told by numerous people that they have changed that position. They've recognized they're wrong, and they are. The statute, when it was adopted, did not provide that it's retroactive, and in fact, it couldn't provide that it's retroactive. It would be probably a constitutional issue. So I'm comfortable saying to you that it is prospective. If you're concerned and there is an election and you don't get 2/3 of the vote, I had one director say, listen, if I don't get 2/3, I just won't take the seat. So that's up to you. But I'm letting you know, I think that if you ran for the board and you were top 5 but didn't get 2/3, and you took the seat and someone wanted to challenge that, in my opinion, that should be a loser challenge. But then again, I'm not going to predict what the division will do anyway. Okay? Certification requirement, that's what we're doing here today, guys. Within 90 days after being elected or appointed. By the way, is there anyone here who's not currently on their board? Anyone not on your board right now? Okay? If you desire to be on your board within the next year, this certificate will meet your certification requirement. Within 90 days of being elected or appointed, you must take either the certification course or fill out an affidavit that you'll honor your documents. I applaud you, even if you filled out that affidavit, for being here and taking the class. The only reason I tell someone to fill out that affidavit is if they get elected, say, in March, and they're going to be out of town for the next 3 months. Fill out the affidavit. When you get back, let's take that education class. Otherwise, I applaud you guys. The more education you can get, the better. Hopefully you're taking good information today, but regardless of wherever you go, I think it's important you get education. But the class itself, that's good for 1 year. So if you are elected or appointed in the next 12 months, and you have the certificate, you would provide the certificate to the Secretary of the Association, whoever maintains your official records, and that would be, you'd now be in compliance with your certification requirement. Keep in mind, and by the way, you're all going to get a certificate today, make a copy of it, and provide it to whoever maintains your records, because if you don't have the certificate on file, and by the way, if you have a website requirement, it should be on your website, then what happens is you are off the board until you meet the requirement. What does that mean? You're told, hey, you don't have your certification, you're off the board. You fill out the affidavit, you hand it in, you're back on the board. It took about 5 minutes. But you guys just get the certificate of it. Okay? Recall, they really screwed that up in Tallahassee, okay? With regard to recalls, the way it used to work is if you were not happy with what the board was doing, either a member or members or a majority or all of the board, you would then try to gather a majority of the owners to recall the board, either at a meeting, which is usually doesn't work, or by a written recall agreement. And you'd serve these agreements on the board, and the board, if they felt that there was defects, they would have to file a petition for recall arbitration on the association's dime and say why. At that meeting, they would to announce why they were rejecting the recall, and then that would be the argument to the arbitrator. Well, for some reason, in 2017, when there was all that stuff going on down in South Miami with fraudulent behavior, they felt that the recall process wasn't efficient, so they removed that requirement that the association file that petition. And that really screwed things up, because now what happens, if the board is attempting to be recalled, and for there seems to be any reason why you believe it's defective, the board isn't rejecting it, the board is simply not acknowledging it. And the owner or unit owner group then has to go out of pocket and file a petition to challenge it. So, if you ever get involved in a recall on either side, the best thing to do mostly is talk with the counsel, talk with legal counsel. Certainly, if it's you're the board, you get with your association counsel and find out. In my opinion, if a majority of the owners say, hey, we want to change, and it is truly a majority of the owners, then the board members or board members should step down. But if it's defective in any way, and there are reasons it would be defective, then it should not be considered, and basically the meeting, which you do have to call within 5 days of being hit with this recall agreement, would simply say, hey, we received some documents from some owners, looks like it purports to be some kind of recall, but it's not sufficient, not facially valid would be the words, and so we're not considering it. Meeting adjourned. And then if those owners differ, they have to now go file their petition. They muddied that up. Electronic voting is now implemented, and in my opinion, electronic voting is something you might want to consider, not so much for your annual election, because you're mailing out ballots and getting them back, unless you have a lot of people out of the country. But also for amendments. If you're trying to amend your documents, it's very helpful to be able to get people to access their computers in that way. The board has to first adopt a resolution which contains, among other issues, the notice to the unit owner, the requirement of their consent, and an opportunity for the owner to opt out if they want to vote. Because if you want to do electronic voting, you need a third-party vendor, and there's some very good ones. And then you need to have a 14-day notice of the board meeting where the board is going to approve the process, and then send out a letter to the owners. And to the question about consent, one of the things that you do in that instance is you ask the owners to not only consent to opting into voting electronically, but would they opt into receiving notices in the future by electronic means? With the understanding that if they do, their email now becomes part of the official records, which means they are open to inspection and other people can get it. But that is, if people are comfortable having electronic means, then that may be an opportunity to do that. All right, on page 20, 24, we talk about this. I have a section called dispute resolution, which I'm also going to pass over, but I do want you guys to be aware of it. We talked about how you enforce your covenants. We talked about fining, talked about the importance of uniformly and timely going after. What this section on dispute resolution talks about is if you have to enforce these covenants, the process that it takes. Most disputes in condominium, under the Condominium Act, are subject to arbitration. Okay? There are a few, like if you're fighting over assessments or if you're looking to remove an unauthorized occupant, those don't go to arbitration, those go directly to court. I will tell you, though, that there is a push, started last year and it's really gaining steam this year, to modify the arbitration rules to now allow you the option, if you have to take further legal action, to either go to arbitration and have it be non-binding or binding, or go to pre-suit mediation. Pre-suit mediation is a process that has been implemented in the HOA Act for years, and in my opinion, quite successful. Far more successful than the arbitration division. And pre-suit mediation is something that if we can get into the Condo Act, what happens now, you guys were asking what to do, well, what you would do is you try to resolve it amicably, and if it doesn't, and you get your lawyer involved, the first thing the lawyer is doing is notifying the individual. Hey, we've got a problem here. We want to resolve it with you amicably. Here's an invitation to mediate. let's sit down at a table with an independent third party, and here's a list for you to choose from. And let's try to figure this out without having to go into arbitration or court. It's far more cost effective. It allows people to sit down at a table before and try to resolve things. And often, especially when things are a little quote unquote personal, having this independent third party in there trying to work things out, let's remove the personal nature of it. So we're very hopeful we can get this implemented in 2020 and then give condominium associations the same availability that HOAs have had for years, which is the option. They're not going to eliminate arbitration, which is what their initial push was, but they want to make it an option. And I can tell you if it passes, my advice is going to be always go to pre-suit mediation. Don't go to arbitration. Okay? The procedures for arbitration are set forth. There is arbitration ordered mediation, but again, if we can avoid having to go through arbitration, then you don't have to file, you don't have to prepare and file a petition, you don't have to put all that together. You simply can meet and try to resolve it now. Okay? So the last subject matter I'm going to touch upon, and then I'm going to have a good 15 minutes or so for questions, is contracts and bids and conflict of interest. Okay? Sir, your question was on contracts again? It's a one-page contract? Like what the enforceability of? Right. Well, again, understand this, guys. When it comes to contracts, if you're not having your attorney review your contracts, I think you're missing the boat. It's just simple as that. And I mean, listen, I understand some contracts might be for $3,000 or $5,000 or $8,000, and there may be a low risk there as far as the dollar amount. However, if that $5,000 contract brings people onto your property, and those people are on your property, and then they get hurt, and there's no workers' compensation coverage, that could be problematic. Especially if the association doesn't have a workers' comp type policy, talk to your agent about that. So even in these smaller contracts, there are reasons to have experienced counsel review them for you. When you're looking at, I have had $1 million contracts that came to us with problems after the fact. And I simply say to the board, listen, on the high end, assuming there was not a lot of back and forth negotiation, you're looking maybe $3,000 to review a contract. It was like 150, 200 pages, maybe. So you're going to spend $1 million, but what you're hesitant on is making it $1 million, $1.3 million. Okay, and that whether it's 250,000, 50,000, whatever it is, when you're budgeting for that, add a line item in the budget for that may be an engineer or a consultant, certainly should be an attorney. Okay? Whoever the attorney is, but I'm just saying, as board members, I think when you're running your businesses, that just makes sense. The first item there under contracts, all written contracts are due by the association for the operation, maintenance, or management of the association. Oh, by the way, sir, if that page was sent over to any attorney with worth their brain, they would have recommended against signing it. Now, that doesn't mean that the board is going to follow attorney advice, but that would be the kind of document you'd say, whoa, wait a minute. And I've seen single-page proposals for hundreds of thousands of dollars. Thankfully, they've come over to us before they were signed, but I have seen them. Because when you ask a vendor, obviously there's a lot of experienced vendors in South Florida, and they have, they'll either use the AIA contract, which by the way is a good foundation, but not nearly protecting enough, or they'll have certain documents. But a lot of them will provide a couple of page proposal. This is the work we're going to do, this is what we're going to charge you. You want to do it, sign here. Or we'll have a little blurb underneath the signature line, we'll provide you insurance and certificates. That's just not good enough. It's not good enough. Okay? When you're, the importance of the contracts talks about, the top there talks about what should be in an operation, maintenance, or management contract. And that's just very specific to that. But when you're talking about contracts for products and services, and that's really where I want to focus, is if it can't be performed in 1 year, it should be it must be in writing. But regardless, any contract you're going to enter into, please have it in writing in some way. Okay? Even if it's something they can do in a month, get it in writing. Bidding requirements are very specific in Chapter 718, 173026. If the aggregate cost of the contract is more than 5% of the annual budget, including your reserves, then you have to obtain competitive bids, whether it be for materials, equipment, or services. Bids. It doesn't say 3, it says bids, plural, so at least 2. Good business practice says you'll get at least minimum 3. Law says at least 2, but good business practice, what you probably should be following. 3 or more. Especially if you look at 2, one might be here, one might be here. That third one will help you figure out whether it's apples to apples. Okay, you're definitely not required to accept the lowest bid if your business judgment dictates otherwise. And there's certain things you're not required to obtain bids for. If there's an emergency circumstance, or in the unlikely event the business entity that you want to contract with is the only source of supply in the county, nor do you need bids for accountants, architects, attorneys, managers, engineers, landscape architects. Of course, they all should be in writing, but you do not need to get competitive bids for those. Okay? Conflict of interest. Okay, this is all right. We've gotten some cleanup, not completely. Okay? Conflict of interest. Under 718.112.2p, it says that the board should not contract with a director or officer, or shall not contract with a director or officer for any services. 718.302.7 basically says, but if you do, here's what you should follow. Okay? And so we've tried to get 718.112.2p out. We're trying again this year. The bottom line is this. If you want to avoid even a chance of a challenge, then don't contract with a director or officer for any service. Material supplies you can as long as you follow 718.327 on it. Don't contract for a service. Sometimes that's not in your best interest. Sometimes there is a director or officer who either themselves or has a familial connection where the business is going to be the best you can find for the best price, be the most attentive, and the board feels, hey, this is in our best interest. So the point is, currently the statute says you shall not. It also says, but if you do. And the but if you do part is what I'm going to go over. Because if you choose to contract with a director or officer, or if the director officer has a financial interest within third degree of consanguinity, that's the language in the statute, I had to look it up. Third degree of consanguinity, that means you have your first degree, which is your parent children, grandparent grandchildren, great-grandparent, great-grandchildren. That's kind of your third degree, so it kind of goes out pretty far. So if the director or officer has a financial interest in the contractual obligation, here's what you now need to do. The cleanup that they did, and quite frankly, that I was involved with. I know this because I helped write it, because we had 718.302.63 and 718.302.7 and 718.112.2. We had 3 provisions. So we were able to combine those 2. And now what it says is, if you have a potential conflict, even if you think there's a conflict, implore you, at the meeting of the board where you're considering the contracts, that director should announce for the minutes, hey, I have a conflict and this is what it is. And so I'm going to present my case, why you should hire me, and then I'm not only abstaining from the vote, which is what it used to say, now I have to recuse myself and walk out of the room. And the minutes should reflect that. Mike announced that we're looking to hire ABC Painting, and he's a part owner of ABC Painting, and he gave his bid, Mike offered his, Mike discussed why he hired him. If you want the minutes, don't necessarily have to say that, but basically Mike announced his conflict, he's abstaining from the vote, he recused himself and left the room. The minutes should say that. Earlier Dan was talking about your minutes, by the way, instead of mentioning minutes, I do want to reiterate what he said. They should not be a transcript. And that's what I said. In that instance, it's important you note it because the statute says that I have to do that. So the minutes should say that I recused myself and left the room. But you don't need to put down in the minutes, nor should you put down in the minutes, that I then said why you should hire me, and these are the good reasons, and then I left the room. The minutes are not a transcript. The minutes should basically say who's present for the board, so it establishes quorum, any motion that's made, who made it, any second who made it, and then the vote. If it's not unanimous, it should indicate who voted against. You could indicate in there, motion, second, discussion followed, and then the outcome of the vote. But you need not get into a lot more. Now, your manager may have their own little notes, but that's not the minutes of the things they have to do. How detailed you want those minutes so you can discuss with them, and in general, that's what the minutes need to be. It's not more than transcript. So now, I made my pitch, I recused, left the room. my competitors can then make their pitches after I've left the room, so I don't get to hear them. Then the board votes. If the board wants to hire me, 2/3 of those board members have to agree. If they want to hire somebody else, you'll need a majority. Okay? At the next membership meeting, if you hired me, at the next membership meeting, I have to announce, hey guys, same thing. Now, by the way, a quorum has to be established at the membership meeting, so who knows what that could be. But at the next membership meeting where there's quorum, I do the same announcement. Hey, I own ABC Painting, board contracting with the board, I made my pitch and then I recused, I left the room, and 2/3 of the board did vote to hire me. And I'm doing the work. And at that point, any owner in the audience can make a motion to cancel that contract. And if a majority of those present agree on the cancellation, that contract gets canceled immediately, and I'm paid up to that point. Now, as a practical matter, by the time you have your meeting, my contract could be finished. But that's what the law requires, that I do all those things. And so long as I have done those things, then it takes a majority of the owners to cancel. If I don't do anything I just said, if I don't announce at the board meeting my conflict, if I don't recuse, if I don't walk out of the room, if I don't announce at the membership meeting, if I don't do any of those things, then by petition of 20% of the owners, my contract can be canceled. That's my punishment. So it's important, if you are going to contract with an interested officer or director, that the officer or director specifically follows those requirements. Okay? And that should be followed if you're going to do supply, they're going to supply you with anything. For a service, again, safest is to just not contract with them until we get that statutory signature removed, but if you do, make sure you follow that. Okay? All right, guys. That is a summary. I hope you guys got some good intel. Thank you. I've been told I have until 12:25, so that gives us a solid 13 minutes for questions. So I saw you right there. We'll go you, and then I will take other questions, guys. And I know Kelly's going to come back up, wrap up. Do me a favor, please. Thank you all again for coming. Thank you again, people, for putting this together. Fill out your surveys before you leave. I'll get you. Fill out your surveys before you leave, and leave them on the tables in the back. Your certificates are there if you have to go. If you want to stick around, I'm going to answer questions for the next 10, 12 minutes.